Yeah, please, my lord.
Yes, just yes.
Lordship, I beg to mention item number 81 to 90.
81 to 90.
Your Lordship.
Yes,
Your Lordship, I am here to receive instruction in this case. If 3 weeks time can kindly be granted to me, Your Lordship.
81,
81 to 90, my lord.
90. What's the matter?
Your Lordship, it pertains to payment of areas of salary, Your Lordship.
No objection. No,
No objection.
when do you want?
After 3 weeks, my lord.
Mr. Angami,
Lordship.
K. Angami,
N. Angami, my
N.
lord.
Angami, learned council, learned state council. Submits that he is yet to receive the instruction. Therefore, press for 3 weeks time.
Lordship.
Prayer not being objected to by Mr.
I, Jamil.
Jamil, learned council with petition. Come on. Is allowed? List up to 3 weeks.
Lordship. Lordship, I have a similar prayer for item number 65.
55,
65, my lord.
65. Contempt petition.
Lordship.
On the prayer of so and so, Anangami Learned Council appearing on behalf of Alice Contemna.
Yes, my lord.
List this matter after 3 weeks.
Lordship. I'm deeply obliged, my lord.
Please, Your Lordship. Lordship, I beg to mention item number 71 and 72.
71, 72.
Lordship, this matter might be fixed for hearing in the first week of October, since the leading counsel is from Gauhati. And in the meantime, liberty may be given so that we can file reply affidavit.
Criminal petition.
Lordship, criminal petition and criminal revision petition.
On the prayer of Mr.
I, Jamil.
Learned Council for the petition. List this matter after 3 weeks.
Lordship, date may be fixed because the leading counsel is from Gauhati.
What do you want?
First week of October, any date, first week.
First week is not, it's not a fixed date. We'll say
Any day on the first week.
Hmm?
Any date in the first week of October.
You tell us.
October. 3rd of October, Lordship.
3rd of October. October.
Lordship.
October is not holiday.
Second.
Anyway, 3rd of October.
Lordship, liberty may be given to file reply affidavit.
No, it's always there.
Obliged, Lordship.
Well, liberty.
Yes, Lordship.
Yes.
Lordship, I beg to mention item 121 to 124.
100,
121 to 124.
121 to
Lordship, in this case, I have instruction to appear on behalf of the respondent's claimant. And I'm here to file my power. We have paid at this minute listed over 4 weeks.
if you are a client, no issue. If you are a claimant, no issue.
After 4 weeks, Lordship.
Mr.
I'm for appellant.
You are for appellant, Lordship. Mr. Swens, on the prayer of Mr. Learned Council. List this matter after 4 weeks, Lordship. Mr. Posiko Pote. For Learned Council to appellant project.
Lordship, I may be allowed to mention item 92 and 93.
92 and 93.
I pray that this matter may come up next week, after a week.
92 and 93. You are for petitioner?
For a petition, yes, Lordship.
I'm for the number 1.
Same prayer,
After a week.
same order.
One more minute.
Next, Lordship.
Yes,
Lordship, I'd like to mention item number 64.
64.
64, Lordship.
Hmm.
Lordship, here I'm for the sole respondent.
Lordship, one of the directors has passed away last week. The Lordship can kindly grant us at least 4 weeks time, Lordship, to get proper instructions.
Director of is
Director of the company, the Global Ceramics Private Limited.
Mr. Fosiko Potil.
Maybe, Sir Lordship,
Yes,
Lordship, the parties are on a compromise talk now, so it might likely end on compromise. So kindly grant 6 weeks time.
in that case, we'll make it 6 months. We're happy, the parties wants to compromise the matter. Because at the end of the day, there's no hurt feelings. Once it is compromised. In that case, on the prayer of both the learned council for the parties, list this matter after 6 weeks.
6 weeks, Lordship.
With this, your lordship. Lordship, I'd like to mention item 98, 9E.
9-8. Yes,
Your lordship, I'm representing the state respondents here, all the state respondents. I may be allowed 2 weeks time to obtain instruction and file state call.
no petitioner. Nobody.
Other side is from the Mabur, your lordship, but
Just you inform.
yeah,
Okay.
I have informed.
On the prayer of Mr. Moinchin, learned senior government advocate. List this matter of 2 weeks.
May I please, Lordship? My
Yes.
lord, I beg to mention item number 117, 117.
Yes,
My lord, if this can be listed after 2 weeks.
2 weeks. You're for respondent, petitioner,
My lord, I'm for the petition.
Takakichu,
My lord,
on the prayer of Mr. Takakichu, learned counsel for the petitioner. List this matter after 3 weeks. 3 weeks,
2 weeks, my
2 weeks.
lord. Ma'am.
May I please, Lordship? Which is item number 9, madam. 9 minutes, 9 minutes. Instructions are awaited, madam. Lordship, on the other, last occasion, Lordship recalls, we had traversals from other direction. And there was a direction from this court, though verbally, to get me a affidavit of the respondent. So that she was a lady that she doesn't want to pursue this matter anymore. Otherwise, there was a compromise date where the FI was that they had settled their meeting. So I am awaiting instructions, madam. I just paid for the listener after 4 weeks, madam.
On the prayer of Mr.
D. Gogoi.
D. Gogoi, learned counsel for the petitioner. List this matter after 4 weeks. Mr.
Kiangami, Lordship.
K. Angami. Learned PP, present.
Lordship, I beg to mention item number 101,
1. Item number 1
101, 101.
or 101. Yes,
Lordship, I have instruction to appear on behalf of respondent number 1 and 3. So can you grant me 4 weeks time to obtain necessary instruction, Lordship?
101.
Lordship.
Mr. K. Angami, learned counsel, submits that he has an instruction to appear on behalf of the alleged contender,
1 and 3, Lordship.
1 and 3. Mr. 1 and 2. Continue, for which he needs some time.
Okay.
Mr. List this matter after 3 weeks, 3 weeks, 2 weeks,
After 4 weeks, Lordship.
after 4 weeks.
Lordship.
So as to enable Mr. So-and-so to take appropriate steps.
Lordship.
That's why I'd like to mention item number 110, 1110,
Yes,
110, Lordship. I'm for the appellant in this case, Lordship.
yes.
If this may be listed up to 2 weeks, Lordship.
On the prayer of Mr. Moajamel, learned counsel for the appellant. List this matter after 4 weeks,
2 weeks, Lordship.
2 weeks.
Yes.
You record his name also. PP. K. Angami. Present.
That's why I also back to mention item number 125 to 129, Lordship.
Yes.
Lordship, I'm for respondent number 6 in this case, Lordship. I'm yet to get an instruction, Lordship. If this matter may be listed after 3 weeks, Lordship.
Is it, it's not hearing, it's not in the hearing.
It's for hearing, Lordship.
No
The last
objection.
occasion, the
Petitioner, no objection.
No objection, Lordship.
Mr. Mojamid, learned counsel for the respondent. Press for and granted 3 weeks time,
Lordship.
3 weeks time. Mr. MS so and so, learned counsel for the petition present. The record, Mr. so and so will state respect.
Much obliged.
Thank you, Sir Lordship. Lordship, I will do item number 112, 13, and 14 on behalf of PN Sharma.
Other than,
112, 113, 114,
okay, when do you want?
11 September.
On the prayer of MS so and so. You are for respondent.
Yes, Your Lordship.
I'm for appellant, Lordship.
List this matter after 3 weeks. Mr. Foseko Pote, learned counsel for the appellant present.
Lordship, can it be listed on 11 September? 11 September.
11 September.
Obliged, madam.
Now, Lordship,
Yes.
item number 80 and 120. I would like to seek for 3 weeks of time.
80.
80 and
80.
120, yes, my lord.
You are for
Respondent, state,
80 and
120.
120. So and so. Praise for and granted. 2 weeks time. 3
3 weeks,
3 weeks
Lordship.
time. Praise the Lord.
My Lord.
MS so and so
They are
appears
asking
for petitioner. Huh?
for the petition.
Petitioner present.
They
And
have
this,
been asking for several-
Huh?
on several occasions they've been asking for.
Can't hear you.
On several occasions
Use the
they've been
mic.
asking.
So, 120 years.
80 after 3 weeks.
It's 120 and 80.
No objection, objection.
They have been asking time for several, in
Ah.
several occasions, on several occasions they have been asking for time.
Why you have taken
Lordship,
several
since
occasions?
we are waiting for instruction.
So
So
objection.
we will make sure to file by next, after 3 weeks.
In that case, you right, on the next date, before the next date fixed, the learned counsel so and so shall
Sure.
invariably file their affidavit in opposition, correct?
Yes, Lordship.
And 120,
120 is for hearing.
you are for petitioner.
No. Respondent.
Have you taken consent from others?
Yes, my lord.
Dear?
No objection, Your Lordship.
Ah,
No objection.
on the prayer of learned counsel for both the sides, Mr. So and so, you record their name, and MS so and so. List this matter after 2 weeks.
3 weeks.
Yes.
Lordship, again, item number 63.
Hmm.
Since we are waiting for instruction, I would like to seek 2 weeks of time.
63.
63 and 69 and 99. We have received an instruction that respondent 4 to 6, we will file by next 2 weeks. 66, we are waiting for the instruction. And 99, we are 99, 6 respondent, 4,
You are first 1 by 1, 63.
63, yes, Lord.
You want some time to file counter affidavit. You are
Lordship,
for
yes, Lordship. State, Lordship.
state. Mr. So and so learned counsel for the London State Council.
63.
That means that he may be granted 3 weeks time to file counter affidavit. We are
Lordship,
not being
and-
opposed by the learned counsel for the petitioner. List this matter after 3 weeks.
And Lordship, 99, we have received an instruction, but to file an affidavit, I would like to seek 2 weeks of time.
99.
Lordship,
Lordship, my senior counsel wants to make a mention in this matter. and my senior, he has just reached the court. So if
No,
he's not,
99 will see order. What
Lordship.
order has to be
Okay, my
passed?
lordship.
Please, your lordship.
Yes.
Your lordship, I beg to mention item number 96.
Hmm.
Your state is yet to receive Parawai's comments, so kindly grant me 3 weeks' time to file my affidavit.
It's 96 includes 97.
Yes, your lordship, 96 and 97.
MS.
AIME.
Learned State Council. Press board. And granted 3 weeks time.
Yes, your lordship.
2 weeks or
3
3 weeks?
3 weeks.
3 weeks time to file contrary. You are for petitioner.
Yes, Your Lordship.
So and so. Let me consider petitioner present. Huh?
Much more.
96, 97.
Maybe, your lordship. Your lordship, I beg to mention hearing item 116. On behalf of my senior, Mr. Gauhati, he has some personal difficulties, so I pray this matter come up next week.
116.
Yes.
On the prayer of Mr. Mr. and so. Learned Council appearing on behalf of Mr. Gauhati.
For the petitioner lordship.
You record his name also. Petitioner present. After 3 weeks. After
Next
3
week.
weeks,
Next week.
next week.
Please, my lord.
I also beg to mention items 7 and 8. We have seen our affidavit for vetting, however, we have not received it back, so I pray that 3 weeks' time may be given up to us.
7 and 8.
7 and 8, yes.
7 and 8. No objection.
No objection.
Obliged.
3 weeks, huh?
May I please, Your Lordship?
Yes.
Lordship, I would like to mention item number 69 on behalf of M. Solo. Here the petitioner is requested to fix the matter next 14 of next month.
69.
69.
And Mr. and so Learned Council appearing on behalf
M. Solo.
of M. Solo. Praise for and granted. 3 weeks. 2 weeks.
14 of next month, after 3 weeks.
3 weeks. List this matter on 14/9. Your respondent.
Yes.
Record her name. Correspondent.
Yes, Your Lordship. Your Lordship, I beg to mention here in item number 111. 111.
111.
Yes, yes.
Ah,
Your Lordship, can you list these matters after 3 weeks?
why?
Your Lordship, on appearing on behalf of the council for the petitioner, the council is indisposed, so Your Lordship.
So and so Learned Council for the Learned Council appearing on behalf of
The
Senti-
council for the petitioner, yes, yes. Mr.
Senti-
Santiago.
Mr. Santiago, Learned Council for the appellant. Submits that Mr. Santiago, Learned Council for the appellant is indisposed. Therefore, praise for listing the matter after 3 weeks. Praise the Lord, list after 3 weeks. Mr. Keangami, Learned PP, present.
Your Lordship, I have a similar prayer for item number 115.
15.
Yes, 1,
Santiago,
115.
same order after 4 weeks.
Oblige, Your Lordship.
May I please, your lordship?
Yes,
On 27th July, this honorable court has directed the petitioner to implement Public Health Engineering Department as one of the respondents.
yes.
Accordingly, the application has been filed for implement of Public Health Engineering Department as respondent number 6 and 5 respectively. In the first item, that is WPC number,
IA 96.
yes.
Any objection? We'll allow you.
And Lordship, in view of that, I may be allowed to file recast petition in both the cases.
Not recast petition, you may file a one-page typed one so that the CS can be CS can accept it and accordingly they'll correct. Mr. City Jamil, Senior Counsel, assisted by
Marilyn Rocha.
Marinal Rota, Lanet Counsel, for the applicant. Mr. Next paragraph. This is by filing this application, the applicant has sought for, applicant has prayed for implement of the chief engineer in the public health engineering department as respondent number 6 in WPC 160 of 2022. Mr. As being a necessary party. Mr. This court on 25/7/2023 has allowed the applicant to take steps for improvement of the PHE department as a necessary party in the connected writ petition being WPC 162 of 2022. Mr. MS
Livika, Your Lordship, for the state.
Libika, Learned State Council has no objection to such objection
Your Lordship, I'm for the private respondent.
objection against the both Libika Learned State Council as well as MS
Kresakira.
got it. Both the Learned Government Council and the Learned Council for the respondent number 5. I have no objection to the prayer made by the applicant. Next paragraph. In view of the above, let the chief engineer in the public health engineering department be implemented as respondent number 6 in the above referred petition being WPC 162 of 2022. Mr. The Learned Council for the applicant shall file a typed copy of the course title so as to enable the registry to take steps. Mr. The IA is disposed of. That's all.
Lordship, in the second case, that is WPC number 129 of 2020. Instead of respondent number 6, it should be respondent number 5.
Respondent 5. Same, chief engineer.
Yes.
Chief engineer.
Same.
You are dear respondent number 4. You are not there.
In
You
the
are not
first
private.
case, only the private respondent is involved. In the second case, that is 129 of 2020, private respondent is not there.
Okay.
That's why it should be respondent number 5 in the item number 2. And in the first case, respondent number 6.
So in that case, respondent number implemented as respondent number 5, and you don't record her name because there's no private respondent. Only the Learned Council, State Council has no objection. Huh? It's okay.
Your Lordship, a notice should be issued to the PhD, Your Lordship.
No, since you are appearing
Yes, Your Lordship, that's why I went
The notice.
to receive the notice, Your Lordship.
in that
They
case,
will serve the copy.
let's before that, before I said the Learned Council shall file that type copy before that. MS Lipika Learned State Council. Since MS so Learned State Council appears and accepted notice on behalf of the respondent, newly implemented
Newly.
respondent number 6, no formal notice be served. However, extra copy. No extra copy. It's an
Extra copy, I
fresh copy.
because it's a different department, your lordship, so I have to serve a notice, your lordship.
So in that case, no extra copy, since so and so appears an accepted notice on behalf of the newly implemented respondent number 6. No formal notice need be served. However, the learned counsel for the learned state council may often necessary instruction in this regard. Correct? In both the cases, we just. No, after that, you say. In main case, in view of the order passed in IA, so and so, so and so, in main case, both the cases, list this matter after 3 weeks.
Please, Your Lordship.
Yes.
Your Lordship, this IA is filed praying for imprisonment of Engineer Pukonizo Kira, Engineer-in-Chief NPWD's respondent in the form the contempt petition.
Yes.
Your Lordship, during the pendency of contempt petition, with respondent number 2 retired from service, and then since there was pending litigation between the two senior most chief engineers under NPWD, respondent number 3, that is Engineer Aita Miran, was given current charge. However, on completion of seniority dispute, by the notification dated 24/7/2023, Annexure B, page 8. The senior most
application is allowed. Accordingly, the engineer Pukrenejo Kera, engineer in chief, NPW, be implemented as respond number 4 in this, in the connected contempt petition being COPC 19 of 2022. Next, the learned counsel for the applicant shall take steps for issuance of notice upon the newly implemented respondent number 4, that is engineer Pukrenejo Kera, engineer in chief, PWD, Nagaland. The learned counsel to the applicant shall also find a type copy of the course title to be course title before the registry for necessary correction in the course title. This notice step shall be within 2 days. Huh? Within 2 days. Continuation then. That's all. List this. And then next, in view of IA disposed of, finally, then in main contempt petition, in view of the order passed in IA 97 of 2023, list the contempt petition after 3 weeks. You have to take steps within 2 days, huh?
Yes, Your Lordship. Your Lordship, I have a similar prayer in item 4.
Yes. Same person,
Yes, Your Lordship.
same order.
Yes, Your Lordship.
Then only IA 98, same order. The replacement is the same person.
Yes, Your Lordship.
Okay. As respondent number 4, huh? Same.
Much
just after-
obliged.
Yes.
Please, your lordship.
Yes.
My lord, I'm aggrieved by the order of the Civil Judge Junior Division dated 14/12/22. My lord, in this matter, I've challenged the agreement order. But since it was rejected, I filed for this civil revision. My lord, here's a delay of 191 days. So this regard notice may be issued to the opposite party.
But in your prayer person, it's 181 days. Prayer person, it's 181 days. You have mentioned 181 days.
My lord, I've informed the registry and then they make the change.
But
Yes. But actually,
in the course
written,
title 191 days,
my lord.
and in prayer person, it's
Yes.
181. Which one is
Yes,
correct?
yes, it was the registry who was supposed to make the change.
Huh?
I filed it on an earlier date. But since there was some correction to be made,
Which one is correct? 181 or
191 should be correct.
Then who will correct it? Not by the registry.
I've informed the registry.
Sir, it is you to correct it.
Yes,
The
my lord.
applicant. Huh?
My lord, it is the registry.
Huh?
Yes. I've informed the registry.
Huh? We'll correct it.
Yeah, please. My lord, allow me to correct it.
No, you may have a word with the registry, but correction has to be done by, has to be by you only.
My lord, allow me to do it so.
Huh?
Allow me to do it so.
Because nowadays, because of CIS, there's a problem. So otherwise, earlier, court used to allow
My lord,
hand,
my
by
lord.
hand. Nowadays, it's very difficult. So you
Exactly.
withdraw and file a fresh. 191, you have to change 191 here only.
My lord,
In prayer person.
okay, fine,
Withdraw and file a fresh.
fine.
Because of the CIS, there's a difficulty.
Okay.
Learned counsel for the petition applicant press for withdrawal of the IA with the liberty to apply press
My
law. The IA is disposed of on withdrawal with a
Obliged.
liberty to the applicant to file a fresh issue advice.
Obliged.
No, you keep it like this. They'll file there only. Actually, unless this come. Delays, if not condemned, why it should be registered? Only filing number should be given. Doing that. So you just get it, the moment it is filed, it is.
Your Lordship is ready for admission hearing, Your Lordship.
Yes, you are on 27/7, you are supposed to obtain some instruction.
Yes, Your Lordship, I have received it, my Lord.
Ah,
I will place it, Your Lordship, during the time of my submission, my Lord.
ah. Who is for petitioner?
Lordship, the counsel for the petitioner was here. I'm told that he was also ready to take up the matter.
Item 6.
Yes, my Lord.
Yes,
On the last two occasions, the learned government advocate.
that's
taken
not for a
some
time
years
to
clear-
obtain instruction. What is the instruction? What is the amount? 18 lakhs.
Yes, 18 lakhs.
And the central government has stopped the scheme project.
That is what the.
The funding agency, I mean, the central government, since they have already
Yes. That is what the
Discontinued
state
the-
is saying, yes, ma'am.
scheme, from where the fund will come.
And then where is the central government unit of India, they are saying that despite.
My senior is on his leg in the other court.
You just give me, what is the instruction? Tell us,
Lordship,
you
in
tell us
fact-
the instruction.
Your Lordship, in fact, allow me to place a letter.
Then that you have to share with him also.
Yes. Your Lordship, why this letter is important? Why this letter is important is, Your Lordship, the central government India, Union of India, in the affidavit.
Yes,
Yes, Your Lordship.
it's of 2015.
Yes, Your Lordship. And the Union of India in the affidavit have said that the project stops on 31/3/2014.
Yes.
And we were informed about it.
When did you issue the
Work order.
work order?
Your Lordship, in 2015.
And it was stopped in, dropped
Stop.
in,
It was stopped in 2015 by an office memorandum, Your Lordship. By an office memorandum for 14/8/2015. It was stopped. After we issued the work order, after the petitioners has completed the project.
so in that you pursue the central government Why the petitioner should suffer?
Your lordship, we have, your lordship. We have, but the agreement saying that the project has been stopped and therefore funding cannot be given.
They are also correct. Once it is stopped, how can they can fund it?
Yes, correct, your lordship.
But the infrastructure created by state, you have to arrange and pay.
Your lordship, the project is never our project.
Whether you get it from central or state, petitioner has no concern. You are not disputing that you have not issued the work order
No, I'm not disputing that.
and work has been completed.
Yes,
What is the work?
it's a construction of lordship. Repeal of the road, your lordship.
It's not in that.
But how did we issue the work order, your lordship?
It's not in New Delhi. Road is constructed here only within the state.
Yes. But how did we issue the work order, your lordship? The work order was issued because the central government.
See, that's what I'm saying. It's between you and the central government.
Lordship,
Petitioner should suffer.
lordship. But who is the parent dependent to pay the amount? The central government, lordship, not us.
Then that is your duty. From where you get the fund, we don't know.
So direction may be given to the central union of India to release the amount, your lordship. Otherwise, this is not our project. This is not a state project.
He is not concerned about the central government. Work order has been issued by you.
But on account of what, your lordship? This is not our state project.
That
On account of the office manual issued by the Union of India. On account of the fund to the.
you sort it out. So
Your lordship, we have already written, in fact, it has written itself.
no, you sort it out with the central government. You cannot make because of all this, you cannot make the petitioner suffer.
No, lordship, I agree. But we have on our end, your lordship, we have tried our best
See,
to get the money from the central government and pay to them.
there is a reason. You should have been vigilant. You have issued a work order. And they have not dropped the scheme after 1 year or two. It's within the same year it has been dropped. Is not it?
No, your lordship,
When did you issue the work order?
the 2015,
Then
2015.
it was dropped, project was dropped in 14 August 2015.
Yes, apparently,
Which month you have issued the work order?
lordship,
Which month?
April, in the month of April. And in the month of August, they have abruptly stopped the project.
When did they complete the,
They were given allotted only 6 months time, your lordship. To
when did
complete.
you complete the
Within that 6 time, within 3 months, we have completed.
6 months? Which,
Within that
which
6
month?
Well, not the exact month, I'm not.
You must know, otherwise nothing. In view of the nature of the claim
Yes,
and the facts of the matter.
completed within that given 6 months.
Okay,
Within 3 months.
April, by August, how much month it is? By August,
4 months.
Then?
4 months.
then
We have completed within that within that 3 months.
did you complete the work before 14 of August?
Yes. But as per the work order, we were given 6 months time to complete the same. As per the work order, we were given 6 months time to complete.
Wait, show me, when did you complete? There's a reason. Mr. Angabi, what is the amount?
Your lordship, total amount is 18 lakhs 70,250.
Come on,
It's
yeah.
in five
You have to
packages.
adjust. Talk to your central government counterpart, you have to pay.
Your lordship, we have communicated to them. In fact, the letter that I have just produced before my lord. In fact, a communication to them, your lordship, to release the amount. Not only that, your lordship, the petitioner has served us the legal notice. Even during that time also, your lordship, they have written to the Union of India. And we have already informed him in the reply to the legal notice.
Before 14 August or after?
Well, I have to ascertain that. Exact date, I cannot give you now.
Where's your,
But the
where's your,
fact remains that I have completed work within the
where's your
date.
completion, the certificate?
My lord, the completion certificate is not there, but it's annexure I, page number 22, my lord.
Huh?
Page number 22, annexure I. This is a letter dated 29 June 2017. It is not disputed that I have not completed the work, my lord.
No, dispute is fairly he has submitted, but the problem is from where you will get the fund? Since the project has already been stopped.
But my lord, the issue is, it's not my.
Where is it? Page
My lord, page
22.
number 22.
What is this?
My lord, this is the letter to the Commissioner Secretary Department of Municipal Affairs, Nagaland. The proposal is sent by additional director and HOD. The subject is proposal for additional plan fund allocation for the work construction of approach short connecting government higher secondary school to Chumikidama Church. Sir, with reference to the subject cited above, I have the honor to state that the Ministry of Urban Development, Government of India has sanctioned the project integrated development of Chumikidama downloads under the scheme UIDSSMT, so and so, right letter number so and so, amounting to rupees 19 lakhs 1946.43. The department was directed to include the work premix carpeting work from Government High School, Chumikidama to Town Baptist Church, and the contractor has completed the work. So there's no dispute that I have completed the work, ma'am. It is an admitted bill, ma'am. I'm just claiming for my rights, my lord. Nothing
This
more.
is the letter of 29 June 2017.
Yes,
Completion he is not disputing.
yes.
This court wants that when did you complete? Before 14th of August or after 14th of August? So that
It was
we can
before.
fix the responsibility. If it is after 14th of August, you will have to. If it is before the 14th August, the central government.
Your lordship, if I may be allowed to make a submission here.
Yes.
During the time when the
When
project was.
the central government council,
I have not received a copy of the.
Ah.
I have not received a copy of the affidavit.
Which affidavit?
Your affidavit.
Original law.
Yeah. Full-time receipt.
No, we have to
Younger
give the
Bhatti.
instruction too. No, there's a letter. Letter, place question.
Younger Bhatti.
This is just instruction.
Mr. Younger Bhatti, is between you and the state government. You have allowed. Both of you have allowed the petitioner to complete the project, and in between you said you have stopped the project. And then still then the state government has allowed him to complete the work. And it's not been paid since 2015, 7-8 years.
Worship,
That
If
too only
the
meager amount of 18 lakhs.
the project was stopped in the month of August. So if he has completed the project within that time, when the work order was still legal, then
That's why I'm asking, when did he complete the work? He's not able to tell us.
that the state and the petitioner will know.
We'll take
Yes,
day after tomorrow.
yes, I'll take instructions in that regard.
Huh?
I'll take instructions in that regard.
But both of you also come with some solution.
Solution is, your lordship, if the central agent can be directed to make the payment because.
Once he has stopped the project, how we can direct? It should be unnecessary. Another petition will come, contempt. Huh?
Abruptly stop.
If Mr. Younger Bhatti can accept that we'll pay, then we'll immediately direct.
Lordship.
But you cannot shirk your responsibility also.
No, your lordship.
Yours is 20%.
Yes, yes,
Is central government is 80%.
lordship.
20% too you have to pay.
Lordship. In the agreement, your lordship, our state share we have already deposited. That is mentioned, your lordship.
Talk to concerned authority. Please, we'll work, come with some solution.
Next week,
This code is very clear. You cannot make to suffer because of your stopping the project and all.
Lordship, to seek instruction, it will take some time, so not this week, it will come up next week or.
Next week. On the prayer of the learned council to the respondents, list this matter next week so as to enable both the learned CGC and State Council Mr. Enangami to obtain definite instruction to resolve the issue of payment of the payment to the writ petitioner for the works which the petitioner has executed in the year 2015. It is the submission of the learned council to the respondents that the project was stopped on 14 August 2015 by the central government. The state government has repeatedly approached the central government for funding of the project. However, the central government has has not accepted the proposal of the state government in view of on the ground that they have already stopped the project in the year 2015. Next week.
Lordship, the petitioner may also be directed to produce the completion certificate. The completion certificate.
The learned council for the petitioner shall furnish the completion certificate on the next date fixed.
Possible.
There must be some solution.
Lordship, pleadings are complete in this case, Lordship. This may be listed for hearing, Lordship.
You are for?
Petitioner, Lordship.
What is the issue?
Lordship,
We may not admit also.
compassionate appointment, Lordship.
On what basis?
Lordship, there's a scheme under the
Scheme.
railways, Lordship.
Railway.
Yes, Lordship.
You are for respondent or petitioner?
Petitioner.
Petitioner. It's okay. Mr. Mojabil, let it counsel to the petitioner submits that pleadings are completed.
Lordship.
This one. Admit the petition, admit the writ petition for hearing. Lordship. List this matter of for hearing in the usual course.
Lordship. Much obliged.
That compassionate appointment you should ask for disposal.
Always, Lordship.
Please, Your Lordship. Your Lordship, this matter was extensively heard before His Lordship, Mr. Justice K. Sema, but the matter could not proceed for disposal for the fact that a similarly situated matter is before the Delhi High Court.
Okay.
In fact, Your Lordship, in the first place, our matter should not have been referred to arbitration, where we are not a party, we are not even a sub-party to the agreement between the contractor, the union, or the state government, Lordship. So going by the principle of the settled principle of law, we should not have been part of the arbitration proceeding, or we could not have been affected by the arbitration agreement. But unfortunately, the matter was, after the matter was taken up before the Honorable Supreme Court, referring the matter to be taken up before arbitration, our subject matter, that is compensation for the properties that has been damaged, our matter was also included in the process of arbitration between the parties. And that is how the decision given by the Delhi the arbitral tribunal of Delhi specifically stated that that issue will not be touched by the arbitral tribunal. Now that is on appeal before the Honorable Delhi High Court. And that is why directly or indirectly we have also been dragged into the issue where we are not even a necessary party, Lordship.
So we're helpless.
You
go to the-
at the moment,
You
yes,
go to
Lordship.
Delhi High Court,
Yes, Lordship.
isn't it?
Yes, Lordship.
You have to approach the Delhi High Court.
No,
If that is your case.
we are not opposed to Delhi High Court. We are not even an interested party there. We're not supposed to be affected also, but it is the parties who have dragged this compensation issue. The union as well as the state are saying that it should be the contractor who is responsible for paying us the compensation. The contractor is saying that it is the union or the state who has to pay the compensation, Lordship. So we're not even an interested party there. For us, our properties have been damaged. We must be paid compensation.
By whom? By whom? Somebody
In
must.
fact, Lordship, we are saying that it is the Ministry of the Road Transport and Highways
What
that has to
what
pay.
they're saying.
No, Lordship, they are saying that the matter is before the Delhi High Court. If not, normally, Lordship, for compensation, it is the ministry that pays, Lordship.
But wrong or right, there is the order of this court. That
My lord.
present case is analogous to the case pending in the Honorable Delhi High Court.
No, I cannot be said analogous, Lordship. That is actually
Is yet to be disposed, therefore, submits the present case may be listed after 2 weeks. Prayer is allowed. Once prayer is allowed.
yes, Lordship, but
Whether that has been disposed of. Or
the word analogous is not applicable in this case. How can it say to be analogous when we are not to be affected in any manner by that case, Lordship?
who has submitted that? Muli,
Yes, my lord.
I
have submitted that.
you have made that submission.
Yes.
According to its analogous method pending before the Delhi High Court.
Yes, my lord. Actually,
How come these are analogous with that
it
case?
depends upon it come out arising out of arbitrary award, my lord. Actually,
Were they party to the arbitration proceedings?
No.
actually the case is arising out of arbitrary award, my lord. Why? Because the state government.
Their grievances are that their property has been damaged. So they want the compensation. So who has to pay the compensation?
State government has to pay, my lord.
Ah,
State government has to pay.
then state government. He's saying you have to pay. You pay.
No, Lordship, we, as far as the state respondent is concerned, Lordship, we
Yes.
are just a supervisory agent, Lordship. So
No,
the
this,
employer is
this,
the MR2, Lordship. So
has it been acquired? Any proceedings under the Acquisition Act?
No, Lordship, no.
Then where is the provision of damage compensation? What is the provision?
In fact, Lordship,
Either it has to be acquired. No acquisition proceedings.
by an executive instruction, Lordship.
Yes.
In fact, my lord has raised a very important issue. I was discussing with my clients also that it has to be freely and fairly compensated under the law, where there should be a proper acquisition process.
Yes.
But by the state's executive instruction that for the project to come to the state, that no land compensation will be taken, but only the damage compensation to the properties that will be accepted. So the clients, they want to go on that line. And by that executive instruction, Lordship, we are asking for compensation for our properties that has been damaged in the course of the execution of the work. And that assessment also, according to the direction of the state respondents, the assessment was prepared by the respective district deputy commissioners and the
Assessment under what law?
damage compensation, Lordship.
Yes.
The values of the properties that has been damaged, that has already been assessed, and the same is not disputed by any of,
Yeah, but then
Yes,
is there
yes.
any provision that the
no, by the technical department, that is the PW Road and Bridges, Lordship, roads and bridges.
where they have
No, they have their own assessment values, Lordship.
no, that's what I'm saying. From where? Under what provision they have draw the power?
That,
assessment
yes,
and
Lordship.
compensation.
Lordship, it is for the state respondents.
Either if
to-
there's no
yes.
law as such, as we
There is, Lordship.
as
There is,
we
Lordship.
understand today, right to fair compensation and the state act we have,
Lordship,
is that it?
there are schedule of rates
Beyond
that is
that-
decided by the
beyond-
state.
beyond
Yes,
that,
Lordship.
the authority who has made an assessment from where they have drawn their power to make an assessment and pay the
Yes.
damage company. What is this? In that case, you have to pay. If you have assessed and if according to you, without resulting to the law, provisions of the law, if you say that this damaged property will be paid and you have assessed that and you pay, why should entangle other people? I mean, other agencies.
In fact, Lordship, as the state council has rightly mentioned, the state is only a supervisory agency. It is the project of the
Then who
Union,
has
Lordship.
the assessment?
Assessment, Lordship, even if it is a union project,
Under what?
normally assessment is made by the state, Lordship.
From where they have drawn the authority.
That is why, Lordship, the PWD roads and bridges, they have this SOR, the schedule of rates. That is
Schedule of
revised. Yes,
Sir,
Lordship.
sir, schedule of rate is something different.
My lord,
Just for assessment,
yes, Lordship.
it's a public money.
My lord,
And we understand, it's a, your private property has been damaged.
Lordship,
That we understand.
my lord.
But for that, there is a law. Is that it?
Yes, Lordship.
So any amount which will be paid to you for damage to your property,
My lord.
it should be in accordance with the law, provisions of the law.
Lordship.
But somebody tomorrow come and say, assess, then this is the amount, how can that is be permissible?
Yes, Lordship.
So that's why I'm asking, if the state has, without there
Yes.
being any authority, if you have assessed, you pay. The project is within the state.
Lordship, the project is the union, Lordship. The project
Who is the requiring authority? Then in that case, you follow the land acquisition.
Lordship, as
provision.
far as the state respondent is concerned, we are just a supervisory agent, and then assessment was done by the deputy commissioner administration. And now since that is not disputed as right.
That's why I asked you whether the deputy commissioner is an autonomous authority in the state.
Lordship, here in this case,
Deputy
Lordship,
commissioner, either as a deputy commissioner or the collector. Under the law, he's the collector. He's a quasi judicial authority under the law.
Lordship, in that view of the matter, Lordship, let it come after next week, Lordship, since here I'm assisting my senior LT Sankam, additional advocate general, Lordship. So he's not present here today, Lordship. So if this matter can come up next week, Lordship.
No, one problem is there's a submission has been recorded by this court. Accordingly, this matter was listed, allowed to be listed after 3 weeks. Number one, Joshua.
Yes, Lordship.
Number two, the key and core issue, when you hear this matter,
My lord.
would be this. Pray that this matter is not listed before this court. I'll go by as per the law, not just the settlement of the parties.
Lordship.
Because there's a two edge problem.
My lord.
One is your private
lord.
property,
Yes, Lord.
other is your public money.
My lord.
And third one would be the development activities. The key issue has to be addressed first.
Lordship. In fact, my lord, as my lord has observed in
just-
some other cases also,
You just don't rely on the DPR.
Lordship,
DPR were not interested. It's a private document.
my lord. And the DPI also has got nothing to do with
Yes.
the present
So
petitioners.
key issue would be under what provisions of law you are entitled for compensation. Number one.
Lordship,
Number two, the government under from where they have drawn the power and authority
to make
to
the
assess,
assessment. Yes, Lord.
make assessment.
In fact, my lord, as my lord has rightly said, to go to the genesis, we have to go by acquisition process first.
And it is not your case
Yes, Lordship.
that it should be properly
Yes,
acquired
Lordship.
and make payment. You are just saying relying on their assessment,
Yes, Lordship.
which appears to be
My lord.
supported by any authority of the law or the power.
Lordship, in that view of the matter, Lordship, let it come next week, Lordship, since I'm led by my senior LT Sankam. Lordship.
It is under where he is.
Lordship, he has some personal difficulty with their lordship.
Additional senior, additional advocate.
Additional advocate general.
And whatever advocate general. These are the issues I think you'll have to streamline. Not
Fact,
just
Lordship,
all
the
of
Advocate
this.
General should be personally appearing to clarify before the Honorable Court, Lordship.
We'll say we'll first give the chance to
No,
additional advocate.
Lordship, my lord.
When then?
Next week, Lordship.
Next week.
Lordship.
On the prayer of Mr.
Bijimon.
Bijimon, Learned Council today. State Council, Learned State Council. List this matter after a week.
No.
On the ground that this no major. But we'll not record it, but then these
No.
are the
Yes, Lordship.
core and key issue.
State may come with that.
Lordship.
You appraise him.
Lordship.
If you have the power, it's okay.
Lordship.
If you have power, whoever has to pay, then you pay. If you don't have, it doesn't survive.
Lordship.
Either side.
Bless you, Lordship.
It's up to 50.
52 to 62, Lordship. My lord, this is a short matter.
Up to 51. Huh? Are you still working?
My lord,
Are you still working? Are
No,
you
Lordship.
serving?
we were terminated,
2019.
discontinued in 2019, Lordship, on the excuse
Hmm.
that the salary component to meet our salaries have already been stopped
Yes.
by the official instruction of the state respondents, Lordship. So we were not aware. After our termination, Lordship, we applied for RTI. And in the RTI, we were able to, we came across the documents, the official documents that says that all salary components are still part of the project, Lordship, the scheme. And these are scheme-related appointments which are co-terminus with the scheme itself, Lordship. So when the scheme is still continuing, why the state respondents have misled this Honorable Court to arrive to a conclusion that the scheme has been discontinued, and for which this Honorable Court, I will take your lordship to the orders,
Yes.
where if the scheme has been discontinued and the state has no financial resource to meet our salary components, then the court cannot resort into directing the state respondents to allow us to continue in our service. That is the observation of this Honorable Court, lordship. If I may take your lordship to some of the documents, lordship.
Yes.
I'll try to make my submission very short, lordship. It's very fat, but the issue is very limited, my lord. May I take a lordship to page number 16?
Why you have made it so fat? Huh?
The number of petitioners, lordship, and the project approval board, the outlay. These documents are fat, lordship.
What is their stand about the continuation of the
No,
funding?
lordship, that's right. The state respondents in an official letter addressed to the department and which was annexed in the state's affidavit submitted before the Honorable Court in the earlier case, that fund provision has been discontinued. Now, if the fund provision is discontinued, naturally, this Honorable Court will not issue the direction, and the petitioners were also of the impression that the fund has been discontinued. That's why there was no extension of service, lordship.
Okay. Proceed.
Yes, lordship. If I may take a lordship to page number 60, annexure 27, my lord, page 60.
Yes.
This was the letter from the state that was addressed to the Director of School Education, lordship.
I think.
And the same was also produced before the Honorable Court, my lord. We'll appreciate that.
Sorry.
Page 60, lordship.
I was looking at the affidavit.
Oh, Lordship. 6-0.
Yes.
Has my lord found it?
Ah,
This is letter dated 29 May 2019.
yes.
To the Director of School Education, Nagaland, Kohima, subject, part-time instructors, PTI and the SSA. Sir, I am directed to refer to your letter number so-and-so dated 22/3/2019 on the subject cited above and to state that a fund provision has not been made. Fund provision has not been made, Lordship, that is important, to meet the salary of the PTIs in the project appraisal board outlay. Hence, it is reiterated that no further extension beyond 36/2018 will be considered.
Yes.
Now, this letter was also in the affidavit, it was presented before the Honorable Court. Then, Your Lordship, I may take your Lordship to page 63, annexure 29. Page 63, annexure 29. Notice, Kohima dated the 26th June 2019. This is by the Directorate of School Education. In pursuance to government directive white letter number so-and-so dated 29 May 2019, which I have already read, Your Lordship, it is hereby informed that all part-time instructors under SSA that no further extension beyond 30th June 2018 will be admissible. This is on the ground that the fund provision has not been made in the project approval board, Lordship, PAB. And may I take a Lordship to page 64. Now, this is the order passed by this Honorable Court on receiving the affidavit of the state respondents. Page 64. This is one of the orders. The relevant portion, my lord, it starts from page 68. 68. May I read, my lord? It's a short order. Heard Mr. So-and-so, learned counsel for the petitioners as Mr. such and such, learned government advocate for the respondents 1, 3, and 5, as well as Mr. So-and-so, learned CGC for the respondent number 2. The petitioners were engaged as a part-time employee in different capacities in the office of the Directorate of School Education, Government of Nagaland, for a period of 6 months, which was subsequently extended on a fixed pay of ₹10,000 per month, have approached this court by filing this writ petition seeking a direction by this court to quash and set aside the notice dated 26/6/2019. That is, my lord, we have read that notice not to discontinue with the service, Lordship. 26/6/2019. That is,
That's 63.
that no further extension, Lordship.
Yes.
Approach this court by filing this writ petition seeking a direction from this court to quash and set aside the notice dated 26/6/2019 issued by the Director of School Education, by which notice the petitioners who were all part-time instructors under SSA were denied extension of their engagement as a part-time employee beyond 30/6/2018. The petitioners have also prayed for a direction to be issued to the respondent authorities to pay off their salaries for a period June 2018 to June 2019. So there were two prayers, Lordship. One was for extension of service by questioning and setting aside the notice dated 26/6/2019, and the other was for payment of the salary for the duties that was rendered in the period where it is said that the services will not be continued, Lordship. For the services rendered, the pays. It has been noticed from the appointment orders of the petitioners that the petitioners were engaged only as a part-time employee at a fixed monthly emolument. If the state respondents have denied the petitioners in further extension of their employment as part-time engagement beyond 30/6/2018, via the impugned notice dated 26/6/2019, as referred to herein above, due to financial constraints. Lordship, this may kindly be appreciated. Due to financial constraints, this court, in exercise of power under Article 226 of the Constitution of India, cannot trust upon the respondent authorities to engage the petitioners as part-time employee for any further period, inasmuch as the engagement of the writ petitioners as part-time employee does not confer any legally enforceable
rights to the petitioners to be further continued as part-time employees with the responding authorities. Then the other part, Lordship, is for the payment of the salaries for the duties rendered. However, notwithstanding the impugned notice dated 26/6/2019 denying any further extension of part-time engagement to the writ petitioners beyond 30/6/2018, the writ petitioners claim that they have rendered their services as part-time employees with the responding authorities till June 2019.
Salary paid?
Yes, that part is paid.
Verified and paid.
Yes, Lordship.
Only now.
The extension
issue
part.
Extension.
Extension part. Now,
Yes.
my lord,
Why it should not, why it should be extended and why it should not be?
yes, Lordship.
These
Yes,
are
Lordship.
all similar.
Then my lord will kindly come to,
Similar orders.
yes, similar orders, but
So many
Very-
petitions.
yes, Lordship.
Hmm.
May I take a Lordship to page 154, 154.
Yes.
This is the second writ petition that was filed. After the first batch of the writ petitioners,
Hmm.
where the state has produced the document saying that fund provision is no more there to cover our salaries. The second batch of writ petitioners, they came only on the ground for payment of their salary because that issue was decided by the first writ petition whether to continue or discontinue with the service. And it is by the instruction of the state respondents that fund has been discontinued, Lordship. Now, my lord, this has been made an issue by the respondents. That is why I'm referring to this, stating that I have not made any prayer for extension in the earlier writ petition. The order itself is very specifically clear that I asked for extension, but because of the instruction that fund has been discontinued. Now, the second writ petition, Lordship, it is not about continuance of service because this honorable court was misled. We, the petitioners, were also misled, Lordship, that no fund provision is there to meet our salaries, Lordship. So the second writ petition or the order starts from page 154.
Hmm.
And relevant paragraphs, Lordship, it starts from page 165, Lordship, 165. May I take your Lordship to the third paragraph, 165. 165, third paragraph.
Hmm.
It is also submitted by the Learning Council that the petitioners have no longer any grievance other than for non-payment of their salaries. This is the second batch of writ petition where I will not be repeating, my lord has already got it, Lordship.
Hmm.
We were of the impression that the fund has been discontinued. Other than for the non-payment of the salaries between 36/2018 to till the date of notification state above was issued, that is 26/6/2019. Mr. So-and-so submitted that since the petitioners were working continuously till the date the notification was issued, they should be paid of their salaries for that period. So, Lordship, for the salary payment is on the court allowed. And my lord, after our termination, Lordship, the petitioners, they applied for RTI application, Lordship. And the reply, Lordship, will see from page 168 onwards, Lordship, 168. May I take your Lordship to annexure 33, page 168.
Yes.
This is the project approval board, which the state respondents before this honorable court by their official letter says that PAB no more included the salary component of the part-time instructors, Lordship. May I read, my lord?
Hmm.
This is Shastri Bhavan, New Delhi, dated 10 July 2019. Subject minutes for the meeting of the project approval board, PAB, held on 7th May 2019 to consider the annual work plan and budget 2019-20 of the Samagra Shiksha for the state of Nagaland. The meeting of project approval board for considering the annual work plan and budget and the Samagra Shiksha for the state of Nagaland was held on 7th May 2019. Then I may take your lordship to the relevant paragraph, the relevant portion, Lordship. May I take your Lordship to page 216. 216. 216. Has my Lord found the page? 216. The second table, Lordship, in the second table, my Lord will see the upper primary teachers contractual elementary. Has my lord seen that?
Yes.
Then art education, part-time instructors, health and physical education, part-time instructors, any other part-time instructors. So there is a total of 333, 211, 211, 211 lordship. And the salary component to be met for this 633 employees in a year, lordship, is 531.72 in lakh, which means it is 5 crores 31 lakhs and 72,000 lordship. This is for 2019-20. Then may I take a lordship to page 226. 226. This is for 2020 and 21 lordship. 226. Has my lord found it? The type copy is at page 227.
Yes. This is what?
This is 2020-21 lordship.
No, this 168 and then 170. So minutes of the meeting,
No, lordship,
detail minutes, huh?
lordship,
Proposals and all.
yes, lordship.
Then the next,
Then 226 lordship. But the type copy is at page 227. This is for the year 2020-21 lordship. 2021 also our salary component is included in the project approval board lordship, which was approved by the union ministry, the union government lordship.
same amount.
Same amount lordship. 5 crores 31 lakhs 72,000. Then my lord at 2021-22 also lordship.
No, this is, it's a sanction order or the minutes proposal?
No, these are sanctioned, in fact, this is approved lordship.
Because it starts from this is page. It's a minutes, detailed minutes,
Yes, lordship.
appears to be detailed minutes,
Yes, lordship.
not the sanction.
In fact, my lord will appreciate from the union affidavit lordship. I will take the
Yes.
lordship to the union's affidavit.
Okay, okay.
But the same thing lordship, 2021, 21-22 also lordship. The same amount approved lordship.
Where?
Now my lord will come to page
228.
no, 228 lord, 227 lordship. That is, and 228 is the 2021-22.
Yes.
Here also lordship, the same amount has been approved lordship. Union's affidavit has more clarity lordship in brief. Now, my lord. When the same amount with a specific mention of a designation also approved by the project approval board. As far as the sanctioning amount part is concerned, lordship, I don't have the documents with me. And I have gone through the affidavit of the respondent number 3 also, who happens to be the main respondent in this case, represented by my learned senior colleague, Mr. Siti Jamir. He will be submitting and I will not be touching to the points where he will be submitting, but the doubts that I have that I want to raise before his own court is even the respondent number 3 also has not annexed any document of how much amount was actually sanctioned. It is just the documents prepared by the department, not the documents which.
Who is the respondent number 3?
That is the
Central.
mission director, lordship. The mission director. Nagaland Education Mission Society, lordship.
The nodal
The model department.
department.
There is not even a single document of the sanctioned amount that was sent from the union government, lordship. It's just the documents prepared by the state respondents, lordship. or more particularly by the officers in the Office of the Mission Director, Lordship. So, Lordship, the prayer in this petition, Lordship, before I show some documents in the affidavits filed by the respondents, Lordship, if I may take your Lordship to the prayer at page 30, Lordship,
Of
of my writ petition, Lordship.
writ petition.
Yes, Lordship, page 30. May I read, my lord?
Yes.
So this is quash and set aside the letter number so and so dated 29th May 2019. That is from the state respondent's lordship, falsely declaring / claiming that the salary for PTI has not been made by the project approval board outlay. The document has clearly proven, lordship, that it is part of the project approval board, lordship. Then the B, lordship. Question set aside the notice number so and so dated Kohima the 26th June 2019, denying extension of service to the petitioners. When there is fund provision, lordship, why should our salary be discontinued or terminated, lordship? They, in fact, then my lord,
Let us do the extent.
lordship. The prayer C, lordship,
Yes, I've seen it.
to constitute a committee to inquire into the mismanagement or diversion of funds, lordship. And we are also asking for reinstatement of service with consequential benefits till reinstatement, lordship. That is the prayer we have made. And so long as the project continues, lordship, our service, since it is co-terminus with the project, lordship, usually the schemes, lordship. So our service should not be disturbed. Those are the prayers, lordship. Then
That may not be possible because you are admittedly on part-time. The nomenclature itself says part-time instructor.
yes, lordship,
And
we are part-time.
appointed for a certain period, 6 months.
Yes, but it has been continuously extended because, lordship, the fund provision is still there, lordship. When there is a fund provision, lordship, for the part-time instructors.
That will hear.
Yes, lordship, but I may take a lordship to the respondent number 5's affidavit, that is the union, lordship. As far as the state is concerned, they have washed their hands and they have put the responsibility on the respondent number 3, that is the mission director, lordship. But this affidavit filed by the respondent number 5. May I take a lordship to page 5 of their affidavit?
Yes.
Now, the earlier SSA, all has been, it has been clubbed and merged with a new scheme that is Samagra Shiksha, lordship.
You are appointed under SSA.
Yes, lordship. Now we are part of Samagra Shiksha.
Okay.
Even before our termination, we have already been included as part of the Samagra Shiksha, lordship. And in the Samagra Shiksha itself, lordship, I have shown your lordship the documents where our salary components are still part of the project approval board, lordship. To the tune of 5,31,72,000, which my lord has already seen.
Every year.
Every year, lordship. It's still continuing. May I take a lordship to Roman 11, lordship?
Yes.
Roman 11. At present, the budget for all 3 schemes is being merged into a single budget provision. This will be the central share to be provided to the states and UTs with the existing fund sharing pattern of 60-40 for all the states. With the exception, lordship, we are within the exception. With the exception that the pattern will be 90-10, 90:10 for northeastern and 3 Himalayan states and 100% for union territories without legislature. So it is 90:10. State share is only 10%, lordship. Then my lord will kindly see the next, that during 2019-20 to 2021-22, the project approval board, PAB of the department estimated a total amount of rupees 30,432.96 lakh for financial support for teachers, out of which rupees 1,595.16 lakh, that is, Lordship, that is 15 crores 95 lakhs, Lordship, was estimated for 633 part-time instructors at the rate of rupees 7,000 per month as proposed by the state of Nagaland. Now, my lord will kindly appreciate this. The first line, 2019-20, 2020-21, 2021-22. So the 3 years, 531.72 lakhs into 3 is 15 crores, Lordship. That is for the 3 years. They have not shown in yearly basis, but the total of 3 years, Lordship. Now, these are the breakups, Lordship. The year-wise details can be seen in the following table. Upper primary teachers, contractual part-time elementary, 2019-20, art, education, health and physical education and others. Number of teachers, 633, that is 211 into 33. Finance, rupees in lakh, rupees 531.72 at the rate 7,000 per month for part-time teachers. That is 2019-20, 2020-21 also same thing, my lord. 2021-22 also same thing, my lord. As per direction of the Ministry of Finance, Government of India, an aggregate amount has been given in a single net for rupees 7193.52 lakhs considered for elementary school teachers financial support in the financial year 2021-22. Even 7193 is also the same amount, Lordship. It's the same amount, Lordship. Like the previous 2019-20, 2021 also, Lordship. Now, if I may take a Lordship to page number 7 of the affidavit. Here, it is pertinent, small a, Lordship, page number 7, below the table. It is pertinent to mention that here that the recruitment, service condition and deployment of teachers are primarily in the domain of the respective state governments and union territory administrations. That part we are not disputing, Lordship. It is further submitted that PAB did not decide remuneration to be paid in different categories of the staff.
Yes, we have.
Understood, Lordship.
So as a matter of right, you cannot ask for an extension.
No, Lordship.
It's a domain of
No,
the
no,
state.
no. Domain of the
When
state,
and
Lordship.
how. Since
No,
you
that
are-
is a general submission, Lordship. That is a general viewpoint that we are accepting, but
Okay,
the issue remains the fact that
okay,
whether our fund provision to meet our salary.
okay, proceed.
Yes, Lordship. Now, when our salary provisions have already been provided in the domain of the state respondents, Lordship, in the domain, so why our designation is included, the state can always decide to throw away our designation.
The teachers include the PTI.
Yes, Lordship. The PTS, the part-time instructors are also part of it. So if in the project approval board, Lordship, if our salary component is not included, because that is within the domain of the state, whether to include ours or not, it is within the domain which we're not disputing, Lordship. But we are part of the project approval board, which has been approved and the fund has been provided in the ratio of 90:10, Lordship.
I don't know. In the state of Nagaland,
Lordship,
Arunachal Pradesh, there is a post called PTI.
my lord.
This is not part-time instructor, it is physical training instructor. It's a regular section post
Lordship.
in the school. So initially I thought it's the same post, but this part-time instructor is something I kind of change.
No, it's like a
It's only
designation,
for a period of
Lord.
certain period.
Lordship. Now, under the elementary education,
The
Lordship.
legislation itself shows that it's a part-time.
My
So
lord,
you have been allowed
yes,
initially
Lordship.
for 6 months and thereafter extended for a certain period.
Yes,
More
if
than-
it-
more than
but
enough.
Lordship.
And I
It
was
is,
worried about whether,
Yes,
you
Lord.
had, I mean, of course, it's a retrospective, but until 2019, you have been paid the salary,
yes, Lordship.
more than enough. What else you want?
Now, Lordship. If my lord may not get
At
confused
best,
with,
we can ask them to, since they have the fund, advertise it. Everyone should apply for a fresh,
no, Lordship.
is not it?
My lord will kindly appreciate this.
Well,
The state, I'm not going into that line. If not, The state has misled the zoning board, which almost amounts to perjury.
That
Lordship, false affidavit was executed before the zoning board to say that fund provision has been discontinued.
we'll see.
But the official document says otherwise, Lordship.
We'll see in a different proceeding that way.
And if my lord may kindly appreciate this.
Different aspect, that is something.
Yes, Lordship. That is why I'm not even praying, but
Assuming
Yes,
that
Lord.
they have misled,
Lordship.
there will be different proceedings.
Now, my lord,
Suppose if we say perjury, that can be different proceedings. For that, you cannot be given the relief
no,
of
Lordship.
extension.
That is their Lordship. However, Lordship,
Because admittedly,
the fact
you are served
remains,
for particular period.
Lordship.
And then they were kind enough to continue, allow it to continue.
Yes, Lordship. Now, Lordship will appreciate this fact, but if my lord may kindly appreciate.
I appreciate and I agree that I think if we accept your submission and the documents, I mean, they have misled.
If not, my lord, yes, Lordship. And my lord will kindly appreciate this. It's my
That-
humble
that
submission,
will
Lordship.
Entitle you for a direction for extension as a PTI. And if not, what else you have?
Now, Lordship,
Except for bringing that there is a perjury.
thanks, my lord. Two things, my lord.
For a direction for inquiry, if still there is stand that there is no fund has been given.
No, Lordship. So if my lord may kindly appreciate these 2 points.
Yes.
Number one, not to be confused with the name of the designation, Lordship. PTI is not the only designation which is under this category. There are others also under the same category, Lordship, who have already gone through the documents. The designation part-time, Lordship. The other designations are also part of the same table and they are under the same category, Lordship.
So
Now, my lord.
let us assume.
Yes,
Let us
Lordship.
assume that funds is available,
Yes, Lordship.
everything is in place.
Lordship.
You just show us that what is your right to continue?
No,
What
Lordship.
is your best,
The basis.
basis of appointment? And then what is your basis for claiming that you should be allowed to continue?
No, Lordship.
Just because fund is there.
My lord, I got your lordship's point, if I have understood correctly, lordship. Usually, the scheme-based appointments are coterminous. So even if it is a scheme-based appointment, lordship, why mislead the zoning board by saying that fund provision has been stopped?
So
There should be a reason, lordship.
that aspect will take care.
Yeah, lordship.
But you want to first establish your right,
Yeah, lordship.
right for extension or
No, my lord.
continuation.
See, if my lord may kindly appreciate this. Even employee, whether it is a part-time or temporary, whatever, under
What
whatever
I'm saying-
category he's
What
employed,
I'm saying, because unless you show the basis or the right,
lordship.
that you should be allowed to, I mean, you have a right to continue.
No, the basis on which we were removed, lordship.
Huh?
My lord may kindly appreciate this the other way around. The basis on which we were removed. Was there any ground that we were not performing, our services were not required?
That aspect will take care.
No, that is why, lordship.
By just because of that, you cannot be allowed to continue. You cannot have a right for continuation.
The basis on which we were removed, lordship. If my lord appreciate that aspect. On what basis we were removed?
What is your initial appointment? How you were appointed? Was it on the basis that until the time fund is there, you will not be removed? Is what the basis? I mean, was it a condition stipulated in your appointment order?
My lord, may I kindly come to one of the appointment orders at page 22, lordship, of my writ petition.
Yes.
One,
22.
no, lordship,
No, it's not 20.
page 33, lordship.
33.
Page 33,
Yes.
annexure 1. May I read, my lord?
One of the, is
Yeah, this is just one of the appointment orders, lordship.
a writ petitioner.
In
one
the
of the-
writ petition, lordship. Order dated 25th February 2015.
Hmm.
Number so and so, in the interest of public service, Sri Kevizobi Mehta, son of so and so of Chichama village, Kohima district, is hereby engaged as part-time health and physical education teacher on a fixed pay of rupees 10,000 only per month at the government upper primary school or GMSPWD under subdivisional education officer Kohima under the following conditions. One, The engagement of service is purely on part-time basis and in accordance with the conditions laid down by the government by notification number so and so. And OM letter number dated 14/11/2014. The engagement is initially for a period of 6 months, subject to further extension. The salary shall be borne by SSA payable in March 2015. Next salary payment is subject to PAB approval 2015-16 lordship. PAB approval, my lord, may kindly appreciate this, of Sarva Shiksha Abhiyan. Program and release of fund from Ministry of Human Resource Development. The paragraph 3, lordship, the point number 3, it squarely covers our case, lordship.
No, it's a matter of,
Okay.
it's a matter of payment of salary.
Yeah.
Read it, next salary payment is subject to PAB approval.
Yes,
Payment of
lordship.
salary, you have been paid.
No, lordship. Now the PAB, lordship. After our termination, lordship.
Please proceed.
Okay. This engagement is purely for a period and liable to be terminated without prior notice and does not confer any right for regularization of service. Such terms, lordship. It is just part of the language which is used.
No,
It is not to be
you
confused,
are
lordship.
asking for regulation, you are only asking for extension.
Yes, lordship. We are only asking for extension, so long as the fund continues, lordship. The employee is directed to join duty within 1 month from the date of issue of this order, failing which the order shall be treated not accepted and cancelled.
Have you annexed this OM 14/11/2014?
No, lordship. We have not annexed, lordship. But my lord will kindly appreciate the condition number 3 of our appointment. Salary payment is subject to PAB approval, lordship.
Because this OM or the government notification,
Lordship.
there's a condition laid down by the government notification.
My lord.
15/10/2012 and OM letter 14/11/20.
No, I can try to find it, lordship.
You see, tomorrow, if your submission is accepted
Lordship.
and there is no dearth of fund
My lord.
for the post. For extension also, as I say, this court has said also that you have to show that your initial appointment is in terms of the rule or the provisions of the law,
My
in
lord,
accordance
my
with the law.
Lordship.
Therefore, these 2 notifications of the office memorandum will be required to look into.
My lord.
Just because you have been appointed for a certain period and this has been disqualified, discontinued. You just
No.
cannot say that there is a fund and you should be allowed to continue.
Lordship.
It's hard to, for this court to accept. Because your initial appointment has to be shown to be in accordance with the law.
Lordship. But my lord may kindly reflect it in the order so that if we can take this matter up on Thursday, I can, but the reflection may be made in the order, lordship. Order sheet itself is not, if not, the state respondents may not like to share the
If you have
documents.
completed, we'll see. If you have not completed, continue. Have you completed?
No, lordship,
I think your
basically,
basis is, it's complete.
yeah, basically,
You
it's
said,
complete, lordship.
you have approached the court and they have said that there's no fund. This has been
It is
discontinued.
discontinued,
therefore- Discontinued, therefore you cannot be allowed to continue.
Yes,
Fund,
lordship.
nothing.
Basically,
Now you
that's it,
came to know that there's a fund,
It's still continuing.
it's still continuing. So why should be, why you
My
have
lord.
misled this court?
Yes,
Had it
lordship.
not been, court would have, passed some different order,
Yes, lordship.
allowing you to continue because there's a fund.
And our salary payment is also subject to PAB approval, lordship.
That has been paid till 2000.
Basically, that is my case, lordship.
That is for a period of till 2016, next salary,
Yes, lordship.
not beyond 2019.
No, lordship.
No, as per
So
your.
the same thing applies, lordship.
Something.
So long as they apply.
But as per this,
It's applied, lordship.
as per this order of 25th February, it's up to 2016. Anyway, that may be continued so long as the
Yes, lordship.
fund flows and
It's implied, lordship.
sanction and approved
My
and
lord.
sanction.
My lord has got it.
Yes,
So in fact, that is my humble submission, lordship.
who is for the Union of India? Are you ready?
Lordship, I have.
As per your affidavit, which he has read, you are supporting him, that you are providing a fund. There is no dearth of fund.
Lordship, it's a creation of
No,
I'm not ready, in fact.
Huh?
I'm not ready.
You are behind. Why you are not ready, sir? We have been hearing him for last 20 to 30 minutes.
So let it come up tomorrow.
He nearly lost his voice. Joshua. Then we'll see, we'll hear the state government. So therefore,
Lordship,
respondent
and for
number three,
respondent number three, and the
main respondent
who is embedded
who has misled this court.
according to Joshua.
Okay.
But in fact, it is he who is misleading the court.
Okay.
On the last occasion, Lordship,
Yes,
to some extent, this matter has been heard.
yes.
And
By
that
this
day,
court or somebody else?
I have furnished
Some
a
other court.
chart
Okay.
with regard to the composition of the Samagra Shiksha.
Sir, this court has heard it or some other court? About this matter?
No, not this court, some other court.
Okay.
And then after a series of hearing,
That is the difficult.
my learned friend has made a submission that the Union of India is a necessary party.
Okay,
So they have not been implemented as a party respondent.
okay,
So we were directed. Time was given to him to implement the Union of India, but Union of India was already a party from the day one.
okay.
So it was not necessary. That's how the matter got deferred.
That's it.
Lordship, to my learned friend has made a lot of contradicting submissions in the sense that with regard to the orders passed by the Honorable Court on the last occasion and with regard to the funding. So far as funding is concerned, it has not been stopped. Funds are coming. And for utilization of the fund, it is being approved by the project approval board. But that is not the final. After the approval, it will be sent and the sanction will be accorded, and accordingly it will be dispersed to the mission. That is how the system works. And in view of fund constraint, the PTA, the petitioners, were compelled to terminate their services because there are priorities. The mission implement the schemes in terms of the directions and guidelines issued by the MHRD. So from time to time, this year, the priority will be given in this sector. Then we have to act accordingly, in which case there are some areas where less important, less priority schemes are there. Those will be curtailed, and then the focus will be given on the priority basis, as per the guidelines given by MHRD. That's how the fund which we receive, the mission receives from the funding agency, do not meet the requirement to maintain the petitioners, and their appointment itself is for a period of 6 months. And it is clearly mentioned in the order that they will have no right for regularization. And after expiry of their terms, extensions were given. And then when the fund could not meet for further continuation of their services were terminated by the state. But before coming to that, Lordship, I would like to highlight how the mission functions. Initially, this Samagra Shiksha, the present Samagra Shiksha, was under two categories. One is Sarva Shiksha Abhiyan, SSA in short, and the present petitioners were appointed when under SSA. And another is RMSA, Rashtriya Madhyamik Shiksha Abhiyan. These two,
Ramsar.
yes, schemes have been amalgamated and coined as Samagra Shiksha.
Samagra Shiksha.
Yes. For risk and
When I was that side, I had a privilege to appear on behalf of this SSA for regularization.
so that makes us easier to make submissions before this court.
But I was for regularization. Today, I tend to forget. I mean, I should forget what I have argued and what I have not. Please.
Now, there are two sections under Samagra Shiksha.
Yes.
One is pre-primary section, that
Yes.
is up to class 8. And the other section is a secondary section, starting from class 9 to 12. Under this secondary section, there are branches like graduate teacher maths, graduate teacher science, graduate teachers English, and primary teachers. Petitioners are none of those category, but they are part-time instructors. They were appointed for a period of 6 months under Sarva Shiksha Abhiyan, SSA in short, prior to the amalgamation, and their services were discontinued on 29 May 2019 due to fund constraint. Now, this Samagra Shiksha is functioning under a governing body. That is, ex-official chairman is the chief minister as its head, and there is a vice president, that is the Minister of School Education. And under that, there is executive committee, and that is chaired by the chief secretary as the chairman, who is the head. And all important policy decisions are taken by this executive committee. Normally the meetings, 2 meetings or 3 meetings are held in a year. And then under the chairman, there is a vice chairman who is the commissioner and secretary of school education. And the functioning of Samagra Shiksha is done under the guidelines of the MHRD, and schemes to be manned by a registered society, registered under the Societies Registration Act. Therefore, the government of Nagaland has constituted a registered society called Nagaland Education Mission Society. In short, it is called as NIMS. And then it was registered under the Societies Registration Act, and the functioning of the society is governed by bylaws and memorandum of understanding of the society, registered society. And the mission is headed by a mission director. Normally, a bureaucrat is being brought to be the mission director, and day-to-day activities are implemented under the supervision of the mission director. And this is functioning under the Department of School Education, and there is a separate wing for implementation of this program schemes, Lordship. Now, coming to the submissions, Lordship, like my learned friend, Mr. Joshua, my submission will be very short as well. And Lordship, come to our affidavit. We have filed affidavit in opposition. Before that, Lordship,
Respond number 3, mission director.
yes, mission director.
Yes.
Kindly come to page 33 of the writ petition. Sorry, Lordship. Page 33 of the writ petition. My learned friend has just referred to this
Appointment.
appointment.
Appointment letter.
And by reading the appointment order, I need not make any submission,
Yes.
because the terms and conditions are very clear that the petitioners are engaged as a part-time instructors for a period of 6 months. That itself is good enough to reject the writ
Is it
petition.
the same post? It said part-time health and physical education teacher. Huh?
Here they have mentioned like that, yes.
Yes, Lordship.
Now,
You said
The-
part-time
The
instructor.
general term is part-time instructor, but part-time instructor has to do some
yes,
responsibility, Lordship. So that is the exact job that they were doing as part-time instructors.
No, but what I'm saying is by this page 33,
Yes, Lordship.
it said part-time health and physical education teacher.
yes.
And you said your post is part-time instructor.
So, Lordship,
Lordship. Activities,
It's the same thing.
yes,
I just wanted to know.
yes. Now,
I'm not trying to draw anything adverse
Yes.
or something. like
Some
that,
are
but
part-time
this
meeting
was-
instructor. Lordship.
whether these are the same post which you are.
Lordship,
you-
I see that in some appointment orders, it is part-time instructor,
Instructor?
meeting instructor.
Okay.
Depends, Lordship.
part
My rank
paragraph
seniority.
1 of the order,
Yes.
it is very clear that purely on part-time basis. That is one. Therefore, part-time basis. Paragraph 2. The word engagement is used and it is for a period of 6 months. Engage, not in any other terms, engagement. Paragraph 4. Second line. And does not confer any right for regularization of service.
In fact, they are not asking. They are not asking for regulation.
Now, their service have been extended from time to time and they were stopped in 2018. However, salaries were paid up to 2019 in terms of an order passed by the Honorable Court. My learned friend has already referred to that order.
Because ultimately in 2019, the discontinuation was for a retrospective effect, though they have been allowed to continue. So no quarrel on that. And they have been paid also.
Now, can we come to the prayer portion? Whether the prayers made in the writ petition are sustainable or not. Page 30, the operative portions. The first prayer is prayer A. Question set aside the letter number so and so dated 29 May 2019, falsely claiming that the salary of PTA has not been met by the project appraisal approval board outlay. So in view of the appointment order, which I have just referred to at page 33 of the writ petition, this prayer cannot be considered and is not sustainable. Prayer A and B is almost the same. Both the prayers cannot be considered. They are not eligible to and entitled to get any relief, either prayer A or B. Prayer A is at page 61 of the writ petition. Prayer B is at page 63 of the writ petition. To save time, I'm not referring to all this. Now, prayer C. Direct the chief secretary to constitute an inquiry committee to inquire into the mismanagement, diversion, misappropriation of the salary of the petitioners. Prayer C. This prayer can also not be considered because of the fact that the chief secretary himself is the chairman of the executive committee and the petitioner is seeking an inquiry to be directed to the chief secretary. I cannot constitute any committee to make an inquiry against me. Lordship. Chief secretary cannot constitute a committee to make an inquiry against him. Therefore,
Will
without-
not direct the chief secretary, will direct if necessary, to constitute a committee by the government, inquire into including the chief secretary.
that will come from this honorable court, but not on the basis of the prayer made by the petitioner in the writ petition. I'm just trying to point out whether the prayers made by the petitioners are sustainable or not. That is what I'm trying
Sir, I
to
have
check.
understood, but you come to this page 168. These input orders 26 June 2019
Lordship,
and 29 May 2019.
19.
You have page 60, 27, except 27.
Page
60.
60.
I think 60. Termination, it's okay. Discontinuation.
Yes,
Fund provision has not been made to meet the salaries of PTA in the project appraisal board outlay.
Lordship, it's like this.
No, just wait. Then you come to page 168.
Yes,
It's the
10
minutes.
July 2019.
Yes. May, June, July. All right.
Yes,
Then come to page 216.
yes,
This is the PAB and the outlay, fund outlay.
yes.
Which is of 10 July 2019 for the year 2019 to 2020. Of course, I understand it is a letter dated 29 May, June, July, after 3 months,
Yes.
2 months. 10 July, June, July, no. Hardly just more than a month. 41 days. 41 days do you have approved this PAB, what do you call it? Project Approval Board has approved by minutes of the meeting, approved the amount.
Yes, it is just a mere approval. Doesn't mean that this is the sanction.
Hmm.
It may or may not be approved by the center.
So where is the sanction? When did it sanction?
That's why they are making a lot of allegations. If there is any diversion, this amount they have received on this date from the ministry, and this amount has been diverted for this purpose, which they are not supposed to do. If at all such diversion is there, let the petitioner show, bring and recall.
It's okay, I understand. This impugn order was passed in 29 June, 29 May. 29 May. All right, page 60. 60.
Yes.
And this continuation is 26 June.
Kindly come to our affidavit, Lord.
Yes, 26 June. Just wait, huh? Then your PAB meeting minutes is of July. There were reason why I'm saying this 29, 26 and 29 July impugn orders, whereby you have said that there is no fund.
So far as 168 is concerned, Lordship, which Lordship is
wait.
referring.
I'm in your favor.
This money is already been paid to the petitioners. Because we have
That's
paid
okay.
salary up to 2008.
No, that's not what I'm saying. What I'm saying is impugn order is of May, June,
Yes,
correct?
yes,
Where you have said, number one, there is no fund, no approval, nothing. Then you have discontinued with retrospective effect in 2018.
yes,
Then this PAB is of 10 July. Within a month.
yes,
Are you saying that at the relevant point of issuing the impugn order, there is no fund? It is a subsequent
yes,
first minutes whereby as per the guidelines, you have to have that kind of appointment on continuation.
Lordship, correct.
And Joshua, is it the case that some other persons have been allowed? Some post, some teachers
Lordship,
have
under the
been
same
allowed
category, Lordship.
continuation under the same scheme,
Yes, Lordship.
Samagra.
Yes, Lordship. Others are allowed to continue except us, Lordship.
There are
So
some teachers.
one more
They are
hurdle,
different.
just wait. One more hurdles, Joshua,
Lordship.
is your impugn, the orders have been passed prior to the approval of the PAB. So
Lordship, our
obviously,
salary, no, Lordship.
no, obviously they were correct.
No, Lordship.
See,
Our salary,
the PAB, the 10 July, and the impugn orders are prior to that.
Lordship, our big wages were also paid from 2018-19, Lordship.
It's okay, it's okay. That
18,
is
19, Lord.
the direction, whatever direction has been complied. Your hurdles, just find it out.
Actually, it
I'm
was.
not asking
continued,
you
Lordship.
to just reply. Just see 29 and 26 June and May and June,
Lordship.
they said no fund. And the PAB has approved it 10th of July subsequently.
They
So
would
obviously
have
have been-
beforehand, Lordship.
No. July is after, is
No,
it
Lordship.
before?
No, what I'm trying to say, my lord, may kindly appreciate this.
Yes.
No project is made overnight. So it was probably prepared and sent to the union government, approved only in the month of July. So lordship, it is clearly,
It's okay.
it's clear that they have misled this on the court,
In that
lordship.
case, we cannot just presume. We'll have to go by the dates. When the impugn order was issued,
Even otherwise, my lord.
there was no approval by the PAB. It is only on 10th of July, maybe within 10 days or 15 days. Isn't it?
Lordship.
Even the 1 day will be a difference so as to, held them responsible to mislead the court. Isn't it? 1 day is also, very, very important. Suppose you make a statement today on the
Lordship.
facts of the matter. Tomorrow, if some other orders come, you cannot say that they have misled the court. Isn't it?
Lordship, the
We
fund
go
was
by the
continuing
orders.
all the while, lordship.
Yeah.
Fund was continuing all the while.
No, that's okay. That we'll see. That,
I do not want to disturb my senior
it's
submission,
okay.
but yes,
Back
lordship.
to you. But then
Okay,
we'll have to make ourselves very clear.
yes, lordship.
So here, that's why I make you aware that this is the factual position that you have to work out. Isn't it?
In
Because
fact,
your main trust is that
the fund was
when the
continuing.
fund was continuing, relying on the PAB 10 July 2019, which on your own showing,
No, lordship.
these orders could not have been issued, impugn orders, 29 May and 26 June.
Yes, lordship.
That is your case.
Yes, lordship.
So that's why I'm pointing out.
Well, if they had no
I
fund,
haven't
lordship.
decided. This court hasn't decided as yet.
No, lord. Yes, lordship.
So I'm just, making you aware,
My lord,
right?
I'll point out few things in my reply, lordship.
Yes. Okay, so
Lordship, again, another very important aspect.
Hmm.
Kindly come to page 68.
68.
My learned friend has roughly read out this, but then I would like to relay something here.
68,
Read petition, Lordship.
writ petition, yes.
Third paragraph, it has been noticed. As your Lordship, read it?
Yes,
May I read?
yes.
It has been noticed from the appointment orders of the petitioners that the petitioners were engaged only as a part-time employee at a fixed monthly emolument. If the state respondents have denied the petitioners in further extension of their employment as part-time engagement beyond 30/6/2018, write the MBO notice dated 26/6/2019, as referred to herein above. Due to financial constraint, this court, in exercise of power under Article 226 of the Constitution of India, cannot trust upon the respondent authorities to engage the petitioners as part-time employee for any further period, inasmuch as engagement of the writ petitioners as part-time employee does not confer any legally enforceable rights to the petitioners to be further continued as part-time employees with the respondent authorities. There is a clear direction passed by this honorable court with regard to their claims, what is being made in this present writ petition. And again, can we come to the affidavit in opposition? My affidavit in opposition at page 66, I have enclosed one of the orders.
Because the state respondent were having a financial constraint. What he's trying to project is all along fund were there. It has been followed. Fund were closed.
It was not for the PTIs, but it was for other
That
components.
you saw. That you saw.
And it is the discretion of
That
the,
is the crux.
yes, mission director.
The forget about PAB. PAB is subsequent,
Yes,
which I have shown. You saw us during the relevant point of time when these impugn orders were issued. Funds were there, but then for a different purpose under the Samagra. Yes, you may.
before that,
If you can show me to
I
that.
will come to that reply to my affidavit in the pleadings.
Yes,
But then for the time being, Lordship may kindly come to page 66 of my affidavit.
66.
Yes, affidavit of respondent number 3. This is an order passed by this honorable court dated 21/10/2019.
Yes,
Here also third paragraph. It is also submitted by the learned counsel that the petitioners have no longer any grievance other than the non-payment of their salaries between June 2018 to 30th June 2019 till the date of the notification stated above was issued. So even here also, they are saying that with regard to the service extension and other things, they have no grievance. But their grievance is for non-payment of salary up to June 2019. This has already been paid, Lordship. Therefore, when the petitioner themselves are saying that they have no other grievance, for what grievance they have come before this honorable court by filing the present rate petitions? That is what I'm trying to project, Lordship.
because it was a submission of the learned counsel.
Yes.
Therefore, there is a different learned counsel.
Parties are same, and the councils are representing the parties. Therefore,
But it was
In
not
the-
Joshua at that one time.
No,
It is also submitted by learned counsel for the petitioner.
In fact,
What do you
I
think?
have appeared in that case also, Lordship.
Okay, but why you have submitted so? Is correct?
No, just
Anyway,
that cannot be misconstrued.
But we find Mr. Isinlo Himbu was the counsel in this matter. Huh?
and
Isinlo is with you now. Isinlo him. Learned counsel who appeared in this matter. Page 66 of the counter affidavit.
yeah.
Oh, Lordship, that's a different case, Lordship.
No,
Lordship,
but same thing.
yes.
I thought he was referring to me.
When it comes to 165,
Yes.
I have just
165.
referred to,
Of your affidavit.
no. I have not referred to this.
Your affidavit.
No, rate
Your
petition
petition.
165.
Okay.
If that is the submission of his in-law, then this will be the submission of Joshua Shiki.
Joshua. You have been
Third paragraph, Lordship, 165,
165,
yes, to order to the 21/10/2019.
which he has read.
Here on the top, Lordship will find advocate for the petitioner Joshua Shiki.
Yes.
And it reads like this. It is also submitted by the learned counsel for the petitioners, have no grievance, have no longer any grievance, have no longer any grievance.
Subsequent rate petition, Lordship.
Submitted by Mr. Joshua Seki.
Yes.
Counsel for the petition.
This is a subsequent rate petition.
Any grievance other than for the non-payment of their salaries between 36/2018 till the date of notification stated above was issued 26/6/2019. This is enough to defeat their case. So now, by filing this writ petition, what do you want now?
No, his case is, we have submitted this, they are admitting. But subsequently, through RTI, they came to know that funds were there. The government has misled this court. Therefore, we have also been misled. Therefore, they have been forced to submit this submission. Is not it? That is his case.
In the first batch of writ petitioners, writ petition, Lordship, we have asked for extension. In their affidavit, they provided this document misleading the Honorable Court as well as the petitioners.
Therefore, he
That
has
no
to
some
submit.
provision is there, Lordship.
You cannot ask for extension, there is no fund, but then they
But
please with
subsequently,
their.
we have to take the post,
That is
Lordship.
his case.
No, no.
If you need diversion, let,
It's okay. See, since you are hearing the entire matter, we'll not go by all this technical thing, I'm not. Yeah. Technical thing, let us not go by that. Let us go by the merit.
Yes, submitted by the state respondents,
It's okay, it's
Lordship. Lordship.
now kindly come to my affidavit, paragraph 8.
Right.
We have explained in detail how the fund is being utilized, how we have received,
That is more important
because
than the submission of Joshua.
if an inquiry is to be conducted, whether, when there is disparate question of facts, whether this honorable court will go into all these
Yes.
disparate questions of facts.
Which paragraph?
Paragraph 8, page 6, Lordship. affidavit of respondent number 3.
Yes.
Yes. This merit lordship. This is on merits lordship. That with regard to the statements made in paragraph 28 of the petition, the deponent picks to state that the project appraisal report are merely proposals and do not present the actual financial position of the mission or reflect the actual amount received by the mission. Mention may be made that the amount sanctioned in the project approval report are not the actual amount received. In this regard, although PAP has approved 226.52 crores, the Government of India released rupees 119.19 crores out of its committed amount of rupees 159.37 crores during the year 2019-20. Since there is a sharp contrast in amount shown in the PAPs and the actual amount received, the mission faces paucity of funds. As such, the mission undertook activities on priority basis as advice directed by the Government of India. In the PAP minutes, the Government of India had advice directed to prioritize certain activities besides the RTE entitlements, such as composite school grants, integrated teacher training, including branding of integrated teacher training package, CRC monitoring of schools and teachers, school-based assessments, school audit, display board on safety guidelines, library grants, sports and physical education, constitution of youth club and eco club for all classes and local display board. The RTE entitlements are free uniforms, free textbooks, special training for each appropriate admissions of out-of-school children, media and community mobilization, training and meeting of school management committee. And then documents are enclosed. Since the mission routinely faces differences in the amount reflected in the PAP and the actual amount received, the mission was compelled to issue a circular bearing number so-and-so dated 16/11/2018 and circular bearing number so-and-so dated 14/1/2022. However, it is stated that since the funds released by the Government of India are not commensurate with the funds approved by the PAP for Samagra Shiksha, then State Mission Office will be apportioning funds on the basis of priority for various activities. The mission receives the fund in 3 installments. This is also very important. A third installment, first installment, and second installment. However, without waiting for the release of the fund from the ministry, the salaries of the teachers are borne by the state government, which is reimbursed when the funds are received from the Government of India. Again, the fund released by the Government of India during 2019 to 2020, rupees 66.61 crores was reimbursed to the state government. During this period, the state government had paid rupees 166.61 crores in salaries for the teachers, leaving an additional deficit of 100 crores. The documents are enclosed. That above, though provisions of TTIs are reflected in the PAPs, this is what just now Lordship has referred to. There is no separate sanction for the PTIs or any other components. It may be mentioned that the PTIs are the only component that could be dispensed with without adversely affecting the execution of the policies of the mission, since the mission had means to other teaching faculties and there are regular training instructors apart from the engaged PTIs, because regular instructors are there and the PTIs are part-time. Given these circumstances, the mission had to act as per the directions in the PAPs in the interest of public policy. Therefore, the petitioner should not have any grievances for following the guidelines and instructions of the funding agencies.
So what's the instruction, guidelines and instruction? Where you can have this kind of decision?
Let me further read
Because
paragraphs.
Sir, because it's a reason. This is the only crux, I think. You are saying you have that authority to decide as per the policy guidelines and instruction of this scheme or the project. And therefore, since there's no separate component for the salaries and for this PTI, though it was approved by PAB, you had to discontinue them, keeping other teachers as per the guidelines and
Lordship.
instruction. You saw that instruction. If you have that power, nothing.
Yes, Lordship.
Otherwise, if you don't have that power or the guidelines and instruction, there's an element of discrimination
Exactly, Lordship.
under the same scheme.
Lordship, we kindly come to page,
Yes.
it starts from page 14, no. Page 14, but relevant portion to cut short,
Yes. It's the same.
page
same-
18
Yes,
and 19.
yes.
Here, in the second column, in the second box, activity master.
Hmm.
In the second paragraph, Lordship will find in the poll letters, activity master,
Page 18.
page 18.
Okay, okay.
In the second box, Lordship will find,
Hmm.
and first, second, third, fourth, fifth, sixth line.
Hmm.
Upper primary teacher contractual elementary,
Yes.
art education, part-time instructors, PT.
Hmm.
Figures are shown. Health and physical education, part-time instructors, figures are shown.
Yes,
And then any other part-time instructors, figures are shown.
yes.
And then,
177, 177.
yes, come to next page, annexure P.
Hmm.
Common up India sanction, sanction numbers are given, dates are given, and on the extreme right column, the in course, the amount is given.
Hmm.
This is for 2019-2020. Amount released by the Government of India.
Hmm.
And the amount released by the Government of India is much less than the PAB. PAB approval, Lordship has seen in page 18. This is PAB approval.
It's okay, we accept this. It's a much lesser amount which the PAB approved. But then you just show us this guidelines and instruction
Page
where you can
20.
have.
Page 20.
And the amount which is in composite and not in, it is not for PTI.
This is the letter from the Government of India to the accounts officer, MHRT, for release of the fund.
2,488 is how much? Lakhs.
It is 24 lakhs,
24
24 crores. Lord.
24 crore, yes, it's written. Then this is 119 is in crore.
Yes.
119 crores.
Yes.
It's okay, this release of amount, this is 24 crore and 100, you are admitting that this is one of the condition with this. This must be 24 crore is the part of 119. But I would like to see the guidelines which you have read, mentioned in the guideline and
Lordship,
instruction.
by reading another 3 paragraphs will make more clear, Lordship.
It's okay, one by one, let us understand one by one. You may be correct. If you have that, the guidelines and instruction says so, you may be correct.
Yes.
So I just want to see
And
that
Lordship,
this is your statement or not, of course, but then there is a guidelines. You have gone by the, followed the guidelines and instructions. So as that.
the main prayer of the writ petitioners
It's okay.
is to reinstate
I've heard it.
and to make the payment.
Yeah, I've seen this. It's okay.
So whether in this proceeding, such a prayer can be granted.
It's okay. That I will consider. We'll consider that aspect which you have made. Maybe for rejection, we'll consider that. This court is yet to take a call. We are hearing you. I cannot prejudge, no?
Yes.
So I want to see that.
Paragraph 11, Lord.
Huh?
Paragraph 11
Before
of the
that, you just show me that instruction and guideline.
instructions and guideline.
Yes, which you have relied.
Along with the
Following the guidelines and
Letter.
instruction, you have followed. Whatever you
Also-
have done by discontinuing or whatever, you have followed the guidelines and instruction of the funding agency. That I
That
would
is
like
why-
to see. If you have difficulty,
Giving
we
a view of
will
that.
see tomorrow. Guidelines and
Not-
instruction. This is the crux, I think, key issue. Your, all the submission I have considered and will consider. But then the power, this is in a scheme. Obviously, you have to act under the instruction, and the guidelines.
Lordship.
That guidelines I would like to see, which you have mentioned here, this paragraph. That the provision so and so, so and so. This will decide the fate of the Mr. Joshua's case.
Madam,
That's all. You have if you have the authority, matter ends there.
to
Nothing
discard
else.
some and accept some in the same category.
It's okay, then next, what you would like to submit?
By reading the 3 paragraphs, Lordship, 11, 12, and 13
Okay,
will make our talk very clear, Lordship.
okay,
Here about the release of fund and then the projection made in the PAP are shown.
okay,
Paragraph 11.
11,
That
yes.
with regard to the statements made in paragraph 32 and 34 of the writ petition, the deponent further reiterates that the funds are not released as per the fund provisions reflected in the PAP. Because we cannot judge on the basis of the PAP. As opposed to the funds shown in the PAP for the year 2021, the approved amount is shown as 210.72 crores, whereas the actual amount received is 107.18 crores. Similarly, approved amount in the PAP for the year 2021-22 is shown as rupees 234.59 crores, whereas the actual amount is released is 83.73 crores. It is pertinent to state that while the fund is yet, government makes payment for the salaries of the teachers, which can be readjusted later as and when the fund is received from the funding agency. Accordingly, during the year 2021, an amount of rupees 164.77 crores was paid to the teachers appointed under the mission by the state government, out of which the mission reimbursed rupees 60.56 crores and the additional amount of rupees 104.21 crores was borne by the state government. for the year 2021-22, an amount of rupees 177.78 crores was paid, out of which the mission reimbursed rupees 43.68 crores. Given these circumstances, the respondents were bound to act as per the advice of the government in prioritizing the activities that needs attention. So from time to time, in which sector the priority should be given, we should focus on that. And then the less priority ones should be ignored. 12. That with regard to the statements made in paragraph 35, 36, and 37 of the writ petition, the deponent begs to reiterate to the preceding paragraph 11 of this affidavit. The deponent further begs to state that the actual amount reflected in the PAB and that which is released is in stark contrast. Resultingly, the nation faces reduction in the funds necessary for all components in the PAB, and as such, as advised by the Government of India, the nation has been using the funds on priority basis, endeavoring to focus on pressing issues so as to ensure that areas that need attention are not neglected. And it is therefore categorically denied that the allegations made by the petitioners that funds have been misappropriated is totally misconceived. It is pertinent to mention that the petitioners have been dispensed from service with effect from 30/6/2018 on account of non-extension of their services. Having agreed by the non-extension of non-release of salary, the petitioners have approached this honorable court by filing a writ petition and by a judgment and order dated 19/9/2019 that I have already referred to your lordship. Passed by this honorable court, the petitioners will bid salaries up to June 2019. However, by the aforesaid order, the petitioners' part-time engagement was not extended, and as such, the petitioners, having no other relief, have taken a way round to disharmonize the smooth functioning of the Samagra Shiksha by showing a colossal amount calculation of misappropriation, which is feasible, but in practical, it is not accurate as the quantum of funds received by the mission is dispersed as per the guidelines and directions of the Government of India. Therefore, the calculation as projected by the petitioners is fanciful, lame, and without even an iota of truth.
Agreed.
And paragraph 13.
It's okay. I've read it. I agree, but I would like to see. You may kindly show the instruction and guidelines.
And kindly come to page 21 of my affidavit.
Yes. 21.
Yeah, yes. ma'am. What are the terms and guidelines? Page 21.
Yes.
This grant shall be further subject to the following conditions. So conditions are given. Lordship is inquiring how it has to be utilized. So while granting the fund, the conditions are given in page 21, starting from 1 to 13. These are the conditions,
No, it's okay.
how
It's
the
not
fund
that.
is to be utilized.
See, your paragraph, which you have first read, no?
Yes, Lordship.
This is terms and condition of sanction and when the amount is allocated. Right?
Yes.
This page 8, that effort, though provision PTS are reflected. This, because of your this statement, I would like to see the instruction and guidelines. See this page 21. 2021 is terms and conditions when the fund is released or allocated or sanctioned. But for appointment or carry out, which you have said that to give preference to some other component, there's a separate guidelines under the scheme. Guidelines and the instruction.
That was not your case in the writ petition. That is why we have not brought.
No, that is the crux, I think. Because what they are saying, you have discontinued our service on the ground that there's no fund.
Yes.
Then they said they were happy. They were asked for the salaries which they have, the period which they have worked. That court has directed, they paid. Now they came to know after the RTI that PAB has approved. And there are lots of funds, including the for PTI. How you can
That's why-
legislate, that's one. Now you are coming by this paragraph, they said there was a provision reflected in the PAB. But then the amounts which you have received is much lesser, isn't it? Much lower than the amount projected in the PAB. Now, there's a other component where it has to be continued as per the RT. Therefore, this PTI, part-time instructor, could not be continued, though there was a fund reflected, that the fund was received very much lower than the, which was reflected by PAP. So that has been done by you as per the guidelines and the instruction on the funding agency. That guideline and instruction, this court wants to see.
Since it is the
And
grievance of the-
I'm sure there's a provision.
since it is the grievance of the petitioner that look here, this is the allocation, but you have received this, but you have not paid. If that is the grievance, let the petitioner come with a specific pleading mentioning about all this.
It's okay.
So that
It's okay.
they
it's
can
okay.
also keep appropriate
That's
reply.
what I'm saying. That's what I'm saying, sir. Let us know about that too technical. Since you are in 226 proceedings, when things are brought. Now this court, why hearing both the sides? Things has to come out. You have rightly said so. This court wants to see as per your statement on ought. That's all, nothing less. If there's a guideline which gives you this authority, obviously, I agree with you. This is a society, a registered society, though involved at the highest political and the bureaucratic level of the state. It's a scheme. A scheme has to be, we cannot insist on the law made by the legislature or the parliament. It has to be under the four corners of the scheme, the guidelines and instruction issued by the funding authority. You are correct. So that provision I just wanted to, that's all.
They will obtain instructions on that,
That is the crux.
and the
I
specific
think that's what.
area.
This may tilt either way. If there is a provision, they will not, obviously the officer, responsible officer, by
Yes.
filing the affidavit, they will not just say on the air.
Yes, Lord.
It's clearly mentioned for following the guidelines and instructions of the funding agency.
Yes, Lordship, it is their affidavit,
So
so,
we'll see
yes,
that,
Lord.
we'll see that.
my lord.
Have you not annexed this? There's no annexure,
Which one, Lord?
but you must be aware that the instruction and guidelines are there.
Yes,
And this authority derive the power from all these instruction and guidelines. Must be a voluminous one.
My lord.
So ask your officer who has signed this affidavit, this para 9, last part of the para 8. Last paragraph of the para 8, page 8. To find it out. Guidelines must be
yeah, Malaya. Sales.
apart from that, anything else? That apart, anything else? you would like to
Page
place?
20, which I have referred to your lordship,
Yes.
that is the instructions from the funding agency. And in terms of that, we are utilizing the fund.
Guidelines. No, it's okay. Utilizing, it doesn't say, it doesn't, that is, I told you this page 21. This is a letter whereby the instruction has been, the condition, terms and condition of the grant has been given. It doesn't tell you with you the
Projection is also given in page 173 and 174. Year-wise,
Your-
PAP approved
your
my affidavit, last page, lordship. Year-wise PAP approved and fund received from Government of India from the year of engagement of part-time instructors till 2021, 2022.
Yes. There's a
Annexure
part-time,
Q.
yes, part-time instruction is also there
Yes,
in 2000.
there are regular part-time instructors are there. It's not that the part-time instructors are only the petitioners who are appointed for part-time
My lordship,
instructors.
there are only
for a period of
633,
6
lord.
months.
Huh?
There are only 633 in total, where we are part of that, lordship. I do not know where my learned senior is making the submission, lordship.
Well, it's okay. I'm hearing him. Just wait.
Hello.
You'll be given a chance. Don't worry.
2021, 21, 22. It is 0.
Where it is?
Page 174, annexure Q.
Ah,
In 172 and 173 also we have projected.
Actually, O and P, lordship.
2021. This is salary paid to the
2021
part-time
is
instructor.
172.
Obviously,
Intervention wise implementation under recurring hit for the year 2021. PAB approval expenditure.
obviously in 2021, they will not be because they are already discontinued. But in 2021, intervention was implementation. Part-time instruction, this is also 0. Expenditure,
Yes.
okay. And then 2021. This is also relevant. Joshua,
Yes, lordship.
0.
Both serial number 19.
Page 172, 73,
Yes, lordship.
74.
No, I have seen, lordship.
0 expenditure.
Yes, lordship. But there is a PAB approval, lordship, of
It's
5
okay,
crore
it's okay.
31 lakhs, lordship.
That's what I'm saying. That's why
Yes.
I'm insisting on that guidelines.
And lordship, even the amount that the state is claiming to have received, the respondent number 3, society is claiming
What
to have
is
received.
in para 8 of this page 8 of you have
My
read the reply?
Yes,
Have you
lordship, I
filed
filed the reply.
Yes, show me.
Lordship, before that.
Para 8, paragraph 8,
Yes.
just one by one. Point was para 8, last paragraph.
Lordship, may I read that page number 3 of my affidavit in reply to affidavit in opposition of respondent number 3. Page 3 of my affidavit in reply, lordship. Paragraph 7. May I read, my lord?
Paragraph 7.
7 of my affidavit in reply to the affidavit in opposition of respondent number 3. The statements made at paragraph 8 is without merit. The respondent has no authorization or direction from the government of India, Ministry of Human Resource Department to divert the funds received for payment of salary to the petitioners towards other activities on priority basis. There are no documents to show that the state respondent has authorization from the government of India to prioritize certain activities that meets attention against the funds received for payment of salary to the petitioners. Contrary to claims made by the state respondents, a careful perusal of the complete documents brings to light the activity-wise details and estimate approved 2019-20 costing sheet, consolidated items, wise estimate and final approved outlay. The consolidated item-wise estimate clearly shows that the proposed salary, as well as the funds approved outlay at rupees 7,000 per month for the 3 categories of PTIs holding total posts of 633, lordship. That is 211 plus 211 plus 211 is equal to 633. The documents also show the final approval funds for the major components under the same Samagra Shiksha scheme, where the salary of teachers amounting to rupees 10,179.12 in lakhs. That is 101 crores, lordship, has been approved, and the same has been released by the government of India MHRD. However, the state respondents has failed to produce any record or receipt to show that the funds have been utilized judiciously in the manner it should have been, as claimed by the state respondents. That it has been clearly mentioned in the state respondents affidavit that the government of India Ministry of Human Resource Development, Department of School Education released the ad hoc installment for implementation of Samagra Shiksha scheme, elementary education EE during the year 2019-20 to the state government of Nagaland in the notification of so and so, wherein it has specifically directed that the sanction amount shall be utilized by the grantee only for undertaking the ongoing interventions fulfilling the RTE entitlements, which includes teacher salary. The state respondents does not have a right to divert the funds without the approval or authority of the government of India MHRD. That is not only illegal, but also amounts to misappropriation. The actions of the state respondents are misleading, discriminatory, and malafide, and are also liable for criminal and disciplinary proceedings, Lordship. That is my reply to the paragraph 8.
It is a false statement, Lordship. What Government of India's instructions have been violated? Let them show, so that we will also get an opportunity to explain.
Due respect to my senior colleague, that is outrageous. It is their document. Let them show before this.
You are making a statement in your affidavit.
Yes, Lordship, according to your affidavit. So let that be produced before this on the court.
Okay. Sir, you clarify that as per the instruction and the guidelines, I'm sure it consists of a thick and voluminous.
It's thick.
You find out, you ask your,
Only the relevant.
ask your officer who has signed this affidavit, that relevant, page 8, last paragraph 8.
Yes.
If you can show it, it will be very helpful. If you cannot show it, he may sail
We
through.
will also have.
You also try.
He may get relief, Lordship.
It's okay.
My lord.
Then tomorrow, can it be? And
I have not received the affidavit.
sir, provide him. We'll finish it by tomorrow because we have spent considerable amount of time. So by tomorrow,
Yes.
you be ready. You are the funding.
Yes.
You are the big boss.
I have already filed my affidavit and amount that has been.
But I'll hear you tomorrow.
Was not genuine. That's why I want to check the affidavit.
Sir, furnish, ask your junior to furnish.
Yes.
Whatever affidavit you want to exchange today, you exchange it. We'll complete it tomorrow. Our Mr. Joshua Sekhi, learned counsel for the petition. Also had Mr. Siti Jamil, learned senior counsel, assisted by Ali and so and so. Learned counsel for the respond number 3. Angami, sorry. Learned counsel for the state response. Learned state counsel for 1, 2. 1, 2, and 4. 5 is central government.
Yes, sir.
Gauhati.
So you know.
Learned counsel for so and so. Hearing remains inconclusive. Stop. Hearing will be continued tomorrow. That is 22nd, 8/20/23. Please stop. The learned Senate council.
Tomorrow it cannot be possible because I have not gone through the affidavit of the.
It's okay. We'll tell you what is their case. You just get the affidavit, please kindly go through tonight. If you have difficulty, we'll tell you. You have heard both of them. Like me. We have heard them all. All of us have heard them. So you try. But we'll not adjourn. We'll complete the hearing tomorrow. Judgment, I don't know. Leave it to the court, but the hearing will complete. Learned senior counsel appearing on behalf of the, in behalf of respond number 3. Shall appraise this court with regard to the statement made in last paragraph of the paragraph 8 of the affidavit in opposition of the respond number 3, whereby as per the guidelines and instruction of the funding agency, that is central government. That we'll hear tomorrow, and then we'll give you some, and then respond number 5. State want to make anything? No.
Not much.
Okay. But then there is something. Okay. Will you hear it?
It's more sufficient to hear my hand.
Okay. No, I think you are safe now.
No, please, Lordship. No, please, Lordship. No, please, mention item number 7.
We'll come back at 2.
Your Lordship,
Resume at 2.
Let it be listed as part.
No, I said indirectly. Hearing remains inconclusive.
There is
Hearing will continue tomorrow. It's same thing.
Lordship, may I be asked to mention Lordship. Lordship, I was in court once, so I could not able to information this morning.
Mention at 2 o'clock, please.
Okay, Lordship.
My lord, I take your lordship indulgence to mention one item number 91.
Go here. 91.
91. I'm taking the consent of the other side, my lord. I seek for an adjournment, my lord, the matter.
91.
91.
I think this has already been adjourned.
91.
Huh? Okay.
91.
Ah.
Lordship.
Criminal petition.
Criminal petition. But that will otherwise also, my lord, it will take time, my lord. My friend is also having this, it will take time. Can it be fixed another date, my lord? 18th of September, my lord, if not inconvenient.
15.
18th of September.
18.
Lordship.
18 September.
Lordship.
On the prayer of Learned Senior Counsel, Mr. P.J. Sekya, list this letter on 18/9/2021.
The interim
Mr.
order,
Prabir, is this?
interim order may kindly continue.
Who is appearing for
There's no
respondent?
interim order,
No,
to be precise.
Huh?
There's no interim order, lordship.
it was passed on 1/6/2023.
It's only to do with,
23.
Learned Counsel, Mr. Posiko Pote present. Learned Counsel to respondent number. Huh? You are for respondent number 2. 2.
lordship.
In that case, you guys just said, just delete that. After the next para, Mr. V. Zimbabwe,
Lordship.
Learned PP. Present, and also Mr. Poseko Pote, Learned Counsel to respondent number 2 also present.
Lordship, there's no interim.
Huh?
Interim order may kindly continue. Interim
Senior-
passed on 1/6/2023.
Interim order passed earlier.
Lordship, there's no interim, in fact, lordship. Lordship may go through the,
He has the,
no, lordship may go through the order 1/16/23. There's no such interim order, lordship. It's
he
only
said
to do with,
22.
it's not lordship can see the report, lordship. There is no such interim order.
Last para.
Only direction is,
Yes, ma'am, that is the order, but till returnable date, though the officer in charge of East Police Station, Dimapur may continue the investigation of the case. However, if
continue
the
the
statement of the petitioner is required to be recorded again, same may be recorded through video conference. So till returnable date, it was there. 1/6. Last, second last paragraph.
operative part is at page 4.
One six.
Lordship is my senior colleague is referring to page 4 of the order. Till returnable date to the officer in charge of his police station may continue the investigation. Continue the investigation of this case. However, the statement of the petition is required to be
Which
recorded
one?
again.
Which
So
one?
the paragraph starts with perusal of the case diary.
Ah,
The second last, oh my God, no, my lord, the second last paragraph, my lord, it appears from the record that the petitioner had earlier opposed this court praying for grant of anticipatory bail. And by order dated 10/4/2023, passed in AB number so and so, this court granted anticipatory bail to him with certain terms and conditions. The protection of anticipatory bail application granted to the present petitioner is still in force. The officer in charge of East Police Station, Dimapur, Nagaland shall keep this in mind while pursuing with the investigation of the case. However, moreover, as the said notice under section 41A is also questioned in this proceeding, and as it appears that the statement of the petitioner has already been recorded in connection with the case, hence still returnable date, though the officer in charge of the police station, Dimapur, may continue the investigation of the case. However, if the statement of the petitioner is required to be recorded again, same may be recorded through video conferencing. That part may continue. That's what I'm submitting.
It has not been done. Has it not been done?
No, not yet.
It's okay. Interim order passed earlier shall continue. There's an order to record his statement through video conference. That has not been done. That will continue.
Okay.
Please, Your Lordship, may be pleased to mention item number 78.
78,
Yes, Your Lordship, 3 weeks will be granted for filing counter.
78. On the prayer of MS State Council, huh?
Yes, Your Lordship.
Last has been given, Your Lordship, to the Kohima.
Is this matter after 2 weeks so as to enable her to file counter affidavit? Mr. So and so?
M. Solo, Your Lordship.
Huh?
M. Solo.
M. Solo.
Your Lordship.
Learned Council for the petition of president. Huh?
Your Lordship, I also beg to mention hearing item number 118 and 119. Your Lordship, let the matter come up on 24th, Thursday, Your Lordship, this Thursday. 118 and 19
18 and
on Thursday, Your Lordship.
who is for petitioner? Any objection? After a week. On the prayer of the learned State Council, MS so and so, list this matter after a week for hearing.
Much obliged. May I please, Your Lordship, I beg
Yes.
to mention item number 79, Your Lordship.
79.
Yes, Your Lordship, we filed our affidavit and reply on 16th August. And the copies have been served this morning, so if this matter can be fixed for admission hearing after 2 weeks, my lord.
79.
Yes, Your Lordship.
What is IA about? IA is for what? 79. Item 79.
Yes, Your Lordship, we able to file a reply to the affidavit in, the complaints affidavit filed in, with petition, Your Lordship.
What is IA?
I is to stay the ongoing work, Lordship. I is to stay the ongoing work, Lordship. To let
Who has filed this?
the petitioner.
Hmm.
The petitioner has filed the IA to stay the ongoing two-lane work, Lordship.
MS. Your name
Limika
is-
Kinimi,
Huh?
Limika Kinimi, Your Lordship, on behalf of Mityo Kota.
So and so, learned council appearing on behalf of MS Nitya Khoja, first for and granted 2 weeks. List this matter after 3 weeks, 2 weeks.
Yes. Much obliged.
BG Mobi, learned. State Council President, huh?
My Lordship, item number 73, 74, 75, 76, 77, I've consulted. So I would like to request to refix on date 24, that's Thursday.
Before this court,
Yes, Lord.
what is this review? Order against
Additional AG, I'm mentioning for additional AG.
next
Indian
week,
song,
next week,
next week.
on the prayer of so and so appearing on behalf of learned additional advocate general, list these matters. From 73, huh?
73 to 77.
77. After a week.
Lordship, I would like to mention again, 99, item number 99.
99,
Yes, Lordship.
99.
Lordship. I would like to seek for 3 weeks of time to file an affidavit.
For government,
Lordship.
state respondents,
Yes, Lordship.
MS so and so, learned council, learned state council, pressed for and granted 3 weeks time to file counter affidavit.
Okay.
Please, Lordship. Lordship, I beg to mention item 102. If this
Huh?
102, If this matter can be listed after 2 weeks.
102. Objection?
No objection.
On the prayer, you are for?
For the respondent, Lordship. Respondent one.
MS Swenso learned consent appearing on behalf of respondent. Press for and granted 3 weeks time. List this matter after 2. Mr. B. Devnath Land. Counsel for the appellant present.
May I please, my lord, item number 94 and 95. Yeah. 94, 95, lordship.
Yes.
May be listed after 1 week, lordship.
Why?
I have personal difficulty today.
Where are you going? Is there entry model?
Yes, Lordship.
Anyway. The on the prayer of Mr. B.G. Momi. K. Angami, learned public prosecutor. List this meant after
1 week, lordship.
1 week.
Pleasure.
MS Swenso, learned counsel for the petition present. Both the 94 and 95.
Pleasure, lordship.
Interim may be continued, Lordship.
Interim order was earlier still continued. Earlier, interim order was earlier to continue.
May I please, your lordship.
Yes.
Your lordship, I propose to do it 66 first. After completing the argument of 66, I want to take a 67, 68, subject to your lordship.
Whatever this.
66 is a writ petition.
John. Huh?
They are connected matters, but issues are different.
This is of 2021, 22.
22.
Do it some other day.
Some other.
Because the preference should be of 2000 hearing matters.
Your lordship,
of
he is
2000
retiring in
2016.
December, your lordship. He is retiring in December.
Next week,
Next week,
we
your lordship, Thursday.
will call the call item. Okay, hearing done. 103, 104, 105. There is 2016 matters in hearing list. Do it next week. Huh?
Came for this matter.
Huh?
I came for this matter. Only, your lordship.
Okay, you came next time also.
But Thursday.
Thursday is not possible. Next week. Right.
Lordship,
Next
next week, I may have difficulty. I'll be out of station. Otherwise, your lordship, this is a short matter.
No, see, madam, there are 2016-17 matters in the hearing list. Yours in admission. 2001 matter. The preference has to go to the old matter. All right. Next week.
He is only asking for question of the FIR and the charge sheet,
Ah.
so that is that case. You'll fix it conveniently. Fix it. Otherwise.
Yes, I do.
Next week or the 24 is not possible.
Your lordship,
24,
24.
24, this court is. No, 24 it's not possible. You said 24.
Yes, sir.
I said next week.
Next week.
Next week you have a problem.
Yes, yes.
Hmm?
I have difficulty next week.
And thereafter?
I have solved that. I'll go back. I have to go back and come.
Huh?
I have to go back and come. Your Lordship. This Thursday. Next Thursday, I cannot sit like that.
Next Thursday,
Thursday. Next Thursday. First. Some problem.
huh?
Some problem, right?
Next Thursday. Then next to next
No,
Thursday.
no, that is the problem. Okay, Your Lordship, next Thursday, 31st, Your Lordship.
Or we can admit the petition and.
No, the
fix
admit it
for-
will
Huh?
go to cold still, I don't want.
Ah. See,
31st, Your Lordship, 31st.
31st,
Yes, sir, 31st.
31st of
I would have done on
August.
29, but my understanding is difficult, that's why I don't think.
And 31st August.
Mm.
On the prayer of the learned concern for the parties, list this matter on 31st, 31/8/2023.
Okay, Lordship.
No, this is a criminal petition for quashing. The petitioner here assails an FIR, my lord.
Yes.
And the informant and the petitioner, they were business partners. Still now they are business partners. There was some miscommunication between them, my lord. And entire edifice of this case is built upon, my lord, a settlement agreement. And respondents has also appeared.
Lordship, I'm for the respondent number 2.
So are you ready?
Yes, Lordship.
It can be disposed of, my lord. They have, the entire foundation was that there was some miscommunication and we have settled this among ourselves. And
Yes.
we have also agreed upon now on amicable terms, subject to payment of certain amounts. This amount has been paid. They have filed an affidavit admitting acceptance, admitting receipt of that amount, and nothing remains, and they are still, I think, still partners.
Yes.
Still they are partners.
Who is appearing for the state?
State, PP was there. Who was there? I don't know. And in fact, in this case, man, there was an interim order which was vacated by this honorable court. Again, my lord, by filing an IA criminal manner, we had to restore it. It's very, we had to file an IA criminal to restore it. The interim order.
Why this was vacated?
Vacated, my lord, since the learned court took a view that since that entire foundation of this case was, my lord, the pillars of this case of moving forward with the application was that agreement. And my lord, the respondent was not appearing, whereas my lord, the responsibility was cast upon the prosecution to serve the copies. Now they have appeared, my lord. We have taken Dusty also. They have filed it. Order dated 19/6.
Huh? There is no order.
19/6, there's an order, my lord, connected criminal, connected IAS was there, my lord. There might be a second file, my lord.
IA.
Yes, sir. IA was moved. So- This is- I'm just explaining everything. They have affidavit, my lord, they have admitted the receipt of every single money, penny money.
This is exactly the Supreme Court discouraged all such type of
No, my lord, due respect, my lord, that was probably in a different context. Recently, Supreme Court came down, my lord.
see,
It was my lord,
the respondent has resorted recourse to the criminal proceedings
my lords.
to recover give whatever may be from you.
My lords.
And they have recovered it. Now they are saying that it should be closed and cooperate with you.
My lord.
Will impose a cost on you.
My lord, with due respect, my lord, if I have read it correctly, subject to correction, my lord.
Then tell us.
My lords. Now they have entered agreement and whole, my lord, if the LCA will also reveal that payment was made to
You
somebody
knew
else.
that
Lordship,
there is no criminal liability. It's surely a business, the business transaction.
yes, Lordship.
It's a money, the civil dispute. then you have approached the court. I mean, criminal proceedings should be set into motion. And then now you have got the
Lordship,
amount which was due to.
yes, Lordship. The
Also-
compromise that was deliberately made along with the consent of both the parties,
That's why
along with the petitioner.
you have abused the process of law.
Lordship, it was collectively made with the petitioner, Lordship.
It's between you and him.
Yes, Lordship. And
Why
I've
is-
also agreed to the
why
terms
the
and
process
conditions,
of-
Lordship.
Process of law has to be abused. Not you, your client will impose a cost.
Lordship, if Lordship, since both the parties have consented in this case, Lordship.
Now, why you have allowed the criminal procedure, I mean, process to be initiated?
Lordship, because I was aggrieved, the payment which I was made,
That is it not a civil dispute?
Lordship.
If this is the civil dispute, it's a pure abuse of the process. You talk to your client, we'll pass the order tomorrow. What do you say?
Lordship, if costs may not be imposed, Lordship.
For cost only, I'm adjourning it. Or else we'll allow the
Lordship, considering that both the parties have
Criminal
consented, Lordship.
process to go on.
In that case,
These are the classic example of abuse of the process.
Lordship, since there was
Had
no
you-
other
had-
way,
Had you not received the amount, you could have insist that
Lordship, there was no other resort also for
No,
us.
there is
Because he was not responding,
there is
the
a-
petitioner was not responding to our calls,
there is a civil court and civil procedure.
Lordship.
let let him go with a stern warning, my lord. Let him
Huh?
send a message. Let him go with a stern warning. Let him go with a stern warning.
No,
my lord.
either will impose a cost
Cost should be.
or will dismiss your petition.
For
it-
his
it-
fault, my lord, why should I suffer, man? It's his fault, my lord. He set in motion. That doesn't require my dismissal of my petition, my lord. It's not my fault.
I'll impose a cost. You also
I'll impose your lordship, man.
support her. Half of the cost you pay him.
If it's symbolic, man, then I'm ready to pay, my lord. If only messages to go, if it's symbolic, then I'm ready, man. And because of this FIR, I have already lost my clients. So too heavy a cost will also rattle my finances. So my lord, if need be, lordship wants to send a message, let it be symbolic.
You have agreed that you have already accepted his money.
No, they have agreed. They have. In
Now
fact,
you have returned.
I have returned, my lord. In fact, that
After
money.
filing of the criminal case.
No, after that, madam, there was because some amount was due. A portion of the amount was due. So after filing, madam, and since there was an agreement,
You say you are still a partner.
yes. So if I am agreeable to the proposition lordship is offering, let it be symbolic and let a message go, my lord, that people cannot abuse this process like that. That to
What
that
you
extent
are-
I agree, madam.
You are also liable.
My lord,
Whatever you are fixing and you are abusing the process of the law.
I didn't abuse, my lord. I am the one who went.
And still you are the partner with him.
Not at that point of time, everything was good when we
No,
did.
this
I
was
went
it-
to jail, man. He didn't.
At
even
the very outset, you said you are still a bigger
Still partners,
partnership.
I had to take instruction, but regardless of that, my lord, I was the one who lost my reputation.
This court will impose a cost
Yes.
and equally you will have to share. 15 lakhs each, 50,000, 55 lakhs each,
My lord,
5 lakhs each cost.
in that case, my lord,
Just try to understand.
I got
Is
the
it-
message, my lord.
Is it not?
Is it? Yes, my lord. in that case, my lord, with that 5 lakhs, 5 lakhs will be too heavy, man. Lordship also consider I was standing at the bar, my lord. If juniors like us stand and get cost of 5 lakhs, my lord.
It's a good sign.
No, my lord, it's the end of us coming in. Which
It's okay.
my lord.
Where's the agreement?
My lord, it's next to it, the petition, it starts from page 32 to 35. Starts at 32.
32.
32 of the petition.
Ajay Raza.
The petition.
Let us see the grounds of compromise. On what basis you have compromised?
It starts at page 34, man.
So only the judgment where the compromise is allowed, when you first you said the respondent number 2 will withdraw the FIR.
My lord.
So you allow him to withdraw the FIR?
My lord. He has agreed.
As per your agreement, compromise date, first it said first party shall withdraw the FIR.
My lord.
Let him go and withdraw the
My lord, what had happened? The police after
And
setting
then you said second party shall move application before the High Court for quashing the incident, including FIR.
This is the application. And what had happened, my lord, when the process was set in motion, it didn't wait to that extent, my lord. I was already arrested, put in jail, I was out on bail, my lord.
So since you have entered into an agreement saying that he will go and withdraw the FIR, let him go and withdraw the FIR.
Well, since, but also, my lord, Point number 4,
is total abuse,
my lord.
total abuse of the process,
I'm not at fault, my lord.
including the High Court. How
My
you
lord.
can make an agreement that you will go and approach the High Court for quashing by the consent of
was-
the party?
I was under duress, my lord.
It is your right, you have to avail. It is not creation, right cannot be created by your private agreement
My lords.
under the law.
That apart, my lord. Also, my lord. That's on factual part, my lord. But on merit part also, my lord, this sections, my lord.
No,
I am not going to that.
your case is, the basis is as recorded by this court also. The
FI was
genesis,
withdrawn, my lord. Yes, my lord.
it's a compromise settlement.
So, my lord,
And your compromise settlement clearly indicates the abuse of the process
my lords.
by you, both of you. How you can have an agreement that you will go and withdraw the FIR and you will, other one will approach the High Court. Have you taken for granted the process of the law? Huh? Both of you.
That I'll refrain to answer because, my lord, I was under duress, my lord. I was just fresh out of jail. And I was the one who was facing the X.
He is your partner.
As of now, my lord, on paper, I think,
Partner in crime,
my lord.
partner in abusing the process of the law.
But I just out of the jail. I was under duress. I am a 60 years old man. I was caught from Gauhati, brought to Dimapur.
No, 56 years, not 60 years.
Sixty minutes. 60 is the. Sixty. Okay. It's a 21, my lord. It's maybe scripted wrongly, but on affidavit, it is 60.
Cause total 56 years. Page
My
two.
lord, this might have kept it because of me, my lord.
It's not,
This might have kept on. I take it on me, my lord. This might have kept because of me.
we'll see tomorrow. We'll dispose it to tomorrow.
My
Think over it, because I find this court finds total abuse.
Well, then it may have to come out some other time. Tomorrow, today I'm leaving, my lord.
Posego photo is.
Forseko photo is there, my lord, but the points which have raised, my lords.
We have heard you. Only problem is you have, both of you have indulged in the.
I am not indulged, my lord. I am trying to explain the position. I was fresh out of jail. I was in a duress. I had to settle it for once and all. So I had to sign this agreement. I had to sign this agreement, though liability was of a different person. Accounts, this documents, materials annexed to
PP. Leonard PP, what do you say?
As Lordship has rightly pointed out, Lordship. Since they have abused the court, Lordship. So Lordship, at this stage, Lordship, exemplary post may be imposed on both the complainant as well as the petitioner, Lordship. Since this matter
Mr. Go, you just show me any judgment, one judgment.
No,
Such
Gyan Singh
type
was
of
there,
case,
Gyan
where-
Singh, Lakshmi
where-
Narayan was
where
there.
exercising the power under 482.
Gyan Singh was there, my lord, and also, my lord, this one has come that if the proceedings, my lord.
Read.
As
If
of now, I don't have it now.
the complainant or the informant by filing a frivolous complaint, and it is turns out to be abusive process of the court, is a ground for quashing. Your ground is, and subsequently, knowing fully well that it's a civil dispute, and the parties has conspired
No, my lord, it's,
to invoke the 482.
my lord, there's no question of me conspiring, my lord. It was the respondent who set in motion.
You are still a partner.
That I have to take instructions, my lord, because on paper they may be, but they may be any transactions, my lord. And that apart, my lord,
Today or tomorrow we'll dispose it of this matter. At best by tomorrow. Show me the judgment where it says in the facts and circumstances.
my lords,
Show me the judgment.
that my lord,
Read the relevant paragraph.
other point of view, my lord, I had.
No, you have to come over this point. Next, we'll come to next point.
No, my lord, since it is all civil proceedings, one of the grounds of approaching this honorable court was that since all was civil in nature, resorting to criminal proceeding is an abuse, my lord. That was one of my ground, my lord.
But what about this compromise? The
Therefore-
whole basis is compromise.
That is one of the basis.
How you can compromise such type of?
That is one of the pillars, my lord.
Huh?
That is one of the pillars. That is, he was approached by the respondent had approached. And I was in the duty.
Annexed it.
I have annexed it, my lord.
Then
And they've also annexed it, my lord. They've also annexed it. An affidavit.
that is the whole conspiracy.
What do I get, my lord? Conspiring. When I bleed money, what I get from conspiring, my lord? I am the one who bleed money,
But you wonder who has already taken from him.
my lord.
You have taken the money from him.
It has been returned, my lord. It also because of. it was
So
not me, my lord.
in the process, why criminal court has been set into motion?
That is up to him, my lord, to resolve,
And why this unnecessary before this court?
my lord.
Unnecessary before this court.
I am here because that is one of the pillars. Second pillar was that since all of the proceedings are civil, my lord, this court is well in its jurisdiction to quash these proceedings, my lord. That is not only one single stand I have taken. I have many more other pillars, my lord. There's one other pillar was that since every proceeding, everything was in, my lord, civil in nature. So I was the one who approached this court that this is civil in nature, please quash it. This agreement, though I have annexed it, my lord, it comes later on, at later point, my lord.
What is the latest judgment?
If my lord allows me,
Yes.
just pausing for a moment, my lord. Connectivity, I'm not. One I'm getting my lord is of May 10, 2023.
How much you have invested?
Lordship,
How much amount you have invested?
Lordship, I've invested
27 lakhs.
22. 22 lakhs 53.
But your FIR says, I have invested, sent investment money amounting to 69 lakhs.
Lordship,
Again, this is false.
48 lakhs 55 was invested in another person's account.
In his account through RTGS. Huh?
Yes, Lordship. Through the advice of the petitioner. There was,
But you have got back 22 lakhs.
yes, Lordship, 22 lakhs
So you have waived the
50,000.
rest of the amount.
Lordship,
You have invested around 69 lakhs,
yes,
53,000.
Lordship,
Huh?
yes, Lordship.
And you got it back 22 lakhs only.
22 lakhs
What are
because
others?
that was the amount which I have transferred in his account, in the petitioner's account, Lordship.
Agreement indicated maximum cap of 60 lakhs. Lordship takes the affidavit of the respondent at paragraph 3. Then he invested
Page
22
28,
lakhs.
page 28 FIR, it says, I have sent investment money amounting to rupees 69 lakhs 53,000 in his account through RTGS. If it is sent through RTGS,
That is not,
an amount of 69 lakhs,
it's not a factor.
Madam, your client is also not free from all this. You have said 69 lakhs.
Lordship,
You got it back 22 lakhs.
Lordship,
You are happy with that.
48 lakhs 50,000
Hmm.
was invested in another person's account.
Hmm.
For procuring the raw materials in respect of the agreement. Lordship.
Yes.
Once I got followed on judgment. It was of May 10, 2023. It discusses everything and it says that since it is taken Bhajanlal into account, more specifically Bhajanlal para 102, sub para 7. If a process is initiated to wreak vengeance, which has a civil color, it has deserves to be quashed, man.
There's no question of vengeance.
Or my lord, whether criminal proceeding is manifestly attended with malafide, or whether proceeding is maliciously instituted to the ulterior motive.
Show me, show me.
Well, it is Bhajan Lal. I have to perhaps mail him.
Are you for disposal of the matter?
I am for the disposal.
Then why you are not ready?
I am ready, my lord, because I was on
You
the,
give me the judgment then.
I have to give it print out, my lord.
Huh?
I have to print out, my lord. I'm using the mobile.
That is what I'm saying.
Yes, my lord.
You are supposed to be ready.
No, my lord, I was on the other impression that because on the earlier occasions, this was the document which court was asking if the honorable court was asking if you have compromised, let the respondent come and file. That was the early impression, my lord. So this is we're traversing in a totally different way, my lord. Different route. That's the reason, my lord.
How you can take a granted from the court that this will be my way of
No, that's
life
not
to
my
Arto
way,
and
my lord.
then,
That was what has.
you are filing, you should file the petition for quashing.
My lord.
You should come ready with everything.
I was ready because, my lord, all the other orders passed by the honorable court also indicate that response of the respondents were awaited, my lord. Even the interim order was vacated on that ground that the petition, the whole foundation was that agreement and the respondent is not coming, my lord. Then on the same ground, my lord, that interim was restored. That since the respondents was not coming and the responsibility of bringing the respondent was upon the.
Forget about the interim. We are for disposal today.
My lord.
You want disposal or you want to fix it for some other time?
I'll leave it to lordship, but I want disposal. Please.
It's give me this.
I am giving my lordship gives me 10 minutes.
After the judgment order is declared, then
After 10 minutes, I can give it money. I'll take out print out money.
how you can guarantee that we can rely on the judgment? Is the actual effects are same?
No.
Then
Facts are not same, my lord. They are, my lord.
you are relying on Bhajan Lal.
Bhajan Lal is there, my lord. Bhajan Lal is there, my lord. I can guarantee.
Bhajan Lal is not 2023. It's 1990, 92.
I'm relying on my 2023. Lordship.
So rely on, give that judgment.
My lord.
Give me that judgment.
No, I am giving a printout, man, after some time, man.
After I dictate the order.
No, that is something in that view of the matter, lordship will grant me some time.
Tomorrow.
Tomorrow, my lord, knows my lord, High Court, my lord. Gauhati, my lord, I have to. They also fix matters, my lord.
I don't know. Day after. You come back day after then.
Okay, my. Let it fix for tomorrow. Let it come tomorrow.
Tomorrow.
Perhaps that cause this will help me.
On the prayer of learned counsel for the parties, list this matter on 22nd, 22/8/2020 for final disposal.
Well,
93. Over. Adjourn.
Your Lordship, in this case, part of my blame as per the judgment in order of this court has been made. But there's one request, the matter may be disposed of it as not pressed, but then the normal nomenclature, which we have called the Lal book, has not been given to me yet. This is with regard to family pension. Now, part of the judgment has been complied with, but one small part remains, which is the authority has not furnished me the Lal book yet. That is the BP pension payment order that has not been furnished. Otherwise, the errors have been made.
Let us see the order.
Lordship, Lordship, this letter was copied to me also. So I'm finishing it. Otherwise, the respondents have not come forward, none of them.
Then
Lordship, my only prayer is that the matter may be disposed of at this stage with the liberty to the petitioner to come again if the Lal book is not finished in time, that the PPO, pension payment order.
no, the court's order said you'll be paid with the family pension
Yes,
that has been paid.
that is being paid now.
Matter ends there. What else you want?
Lordship,
What else you want?
normally the pensioners are given the book, which I have not received yet.
That was not a part of the.
Of course it is not.
judgment.
But
So if
to
you are
make the
agree,
order complete,
you can approach, you can request to appropriate remedy. We'll go by the order of this. court.
otherwise, most of my demands has been made, so.
Not
matter may
most,
be closed.
it's
The matter may be closed.
fully complied with. See page 16,
Yes, Your Worship, I see.
yes.
It has been complied. The last.
If you have agreed by any other thing, which is not the part of this order, you may approach again. There's something, is it not?
All right.
Huh?
Yes, Lord.
Mr.
Apok.
Apok Pongena, learned counsel for the petitioner fairly submits by placing the order dated a letter dated 9/8/2023 addressed to the learned CGSC
And copied to me also, Lordship, at the bottom.
and a copy of which was also furnished to the learned counsel. Fairly summons the respondent authorities have fully complied with the court's order. Complied with the order of this court dated 14/10/2022. Next page. Not next page. Fully complied with the order of this court dated 14/10/2022, for which the contempt petition may be closed. Mr. Next page. In view of the above. The contempt petition is closed. Mr. The copy of the letter dated 9/8/2020 be written in the file. Obliged. One by one,
Yes, my lord.
103,
103.
yes. Isab and how,
Yes, my lord.
yes.
This petition is being filed claiming appointment on land ownership basis, my lord. Unlike the other states, in Nagaland, we have a different land holding system. The land belongs to individual, and for any governmental activities also, land has to be acquired. My lord. In the year 1966, an agreement was executed between the district administration and the land donors. Annexure 16, page 16, annexure A. And then the type copy is at page number 18, my lord. On 2nd day of September 1966, His Lordship got it, page 18. This is the type copy of the agreement.
Agreement
Yes. An
with
agreement
whom?
with the district administration and the local administration.
How do you find? He
Married, my lord.
already agreed earlier with the.
Yes, married, my lord. As already agreed to.
When
we
did you
understand-
agree earlier?
Yes, on behalf
When,
of the.
when? When did you agree earlier?
There was a virtual understanding agreement,
Huh?
verbal agreement. And then it was put into writing on 1966.
This is the extra assistant commissioner.
Yes,
Huh?
yes,
Extra assistant commissioner.
yes, extra assistant commissioner parent.
Parent.
Yes, my lord.
Where's the area?
Area. It is under parent district at Jaluki town. Married, my lord.
Yes.
As already agreed to earlier, we understand on behalf of the Zaluki village hereby offer, number one, that we have voluntarily given away our land as specified below to the Zaluki Kuki Tribal Council for establishment of divisional administrative headquarters by the government. That henceforth we shall cease to have any claim on this land either individually or collectively. That the boundary of the land given in the 18-mile coast on the south, 15-mile coast on the north, Hiralu River on the east, and Hiralu Bridge on the west, and then the relevant portion is paragraph 4. That we decline to take any compensation for the land in question, but request that the government should give every facility to our village in the town area, such as opening of our village block, allotting plot in town, and preference for government service. So, basing on this agreement, this was the agreement that the landowners will be given preference for appointment to grade 4 post. Now, my lord, the page number 20, Annex B. And then this was signed as a token of agreement. We signed, given term impression this 2nd day of September 1966, and then it was signed by the GPs, ex-GPs, and then the MLA of parent.
Yes. Page 20.
Yes, page 20. And then this is a notification issued by the additional deputy commissioner on 21st August 2003. Notification dated parent the 21st August 2003. Number so and so. Married. This is for general information to all concerned department under parent subdivision that as per the written agreement made within the landowners of Zaluki All Village and the government of Nagaland at serial number 4, that the first preference shall be given to the landowners for appointment to the post of grade 4 port staff, and special preference shall be given to the landowners in allocating of small contract works, etc. Hence, all the head of the departments, officers are hereby requested to safeguard the interests of the landowners who have donated the land to the government for establishment of administrative headquarters while considering the above said appointment, allocation of contract works, etc. This was reaffirmed by this notification.
Yes, by the deputy commissioner.
Yes, additional deputy commissioner. Correct.
Additional deputy commissioner. Can he? Has he power? Has he got power? Any power?
Earlier, it was not conferred a district. Now it has been conferred as district. Earlier, it was a subdivision only. Now it is under deputy commissioner. But erstwhile, at that point of time, parent was.
Now this policy has to be taken by the state government.
Yes.
Not by additional deputy commissioner.
But there was, it is admitted that there is an agreement of 1966 that the preference for
1966, there is no government.
Yes, the land was taken by the administrative.
No, what I'm saying is.
Yes, I agree with that, man.
Additional deputy commissioner cannot take a policy decision of the state government. It's a part of the state government.
Yes.
The policy has to be from the top.
Yes, madam.
From the government.
Yes, but as per the agreement, it says only preference. Like it has to be appointed. It's not like question by preference.
Therefore, they could not give you a preference. So better ends there.
Yes. Now, having learned that a boss of medicine carrier, which is a fortnight post, has arisen in the office of the district veterinary dispensary, the petitioners applied against that post on land ownership basis. However, instead of considering the petitioner, the respondent authorities, they appointed the private respondent. That also without any
private respondent.
I'm appearing for private respondent.
What do you say? You are equally entitled. Are you equally entitled?
No, my lord, I'm not the landowner.
Okay.
I'm not the landowner.
Okay. So on what basis you have been appointed? What is the basis of your appointment?
My lord, I had the qualification to be appointed.
How you were appointed? No, there must be some basis. Selection process or
Yes.
just pick up or some recommendation, something like that. Was there any selection
With the
process?
government approval. I was
Ah.
appointed with the government approval.
How the government approved it? The process
My
of
lord,
approval?
The respondent, private respondent also applied for the post. Even the petitioner also applied. All this was processed in different levels.
You know what, it should not be, is it not, should be, as per the constitutional scheme?
My lord, it was a grade 4 post.
Huh?
It is a grade 4 post.
Grade 4 post
Grade 4
also
post.
should not be as per the constitutional scheme. Or just pick and choose. Huh?
My lord.
But how you can claim that this post should be, is it a quota?
No, it's not a quota, but as per, in terms of the agreement, since there was an agreement with the landowners, because the landowners who are laymen, they have donated the land to the government.
Why you after his post?
No,
He or she?
There were a vacancy arise, a vacancy arose. Against that vacancy, I have applied.
Show me where the vacancy, whether this is for donation.
Yes, my lord, page number 21 is my application.
Huh?
Page number 21, Annexus C is my application. Married, my lord. Page number 21, Annexus C. To the director, veterinary and animal husbandry, Nagaland, Kohima, through proper channel, prayer for appointment to the post of office medicine carrier at veterinary dispensary, Gauhati. Respected sir, in reference to the subject mentioned above, the undersigned have the honor to submit this supplication for favor of your application for your kind consideration and appointment, please. That's it is then true, reliable source that Shri Namri Wang, the office of medicine carrier veterinary dispensary, Gauhati, is supposed to be retired from service on attaining the superannuation age on September 2014. In this connection, I would like to put myself as an intending local candidate for the post. All 11 biodata are furnished here below for your kind consideration and necessary action. And this is against the against the retirement vacancy. I have applied. My case was not considered. In terms of the agreement, I agreed the right to be considered. However, the respondent number 5 was appointed against the same post, said post. I have submitted my representation, so that was not considered, madam.
Then you have applied, then
Since after that, Annexure G, page number 28, is the appointment of the private respondent, madam. Page 28, Annexure G is the interim appointment order. By this order, dated
Secretary Jaluki Student Union also recommended your name.
yes, all the local bodies, since the land belongs to the Jaluki, all villagers, for the interest of the community. The Jaluki students also took up the matter.
The respondent number 5,
Yes,
is not from your community.
no, ma'am.
Huh?
No.
Is from where?
He but he's not from all Jaluki village.
It was for 1 year.
Yes, it was only for 1 year.
Still working.
Yes, she's still working.
Still working.
My lord.
Still working.
Yes, my lord.
And then against the appointment of the petition, respondent number 6, I have submitted a representation of the ultimatum. But that was not considered, and in view of which these petitions we filed, madam.
Then
My lord, I would like to place a judgment passed by this honorable court in WBC 316 of 2017. In that case also, the petitioner is the landowner of this, also belong to Old Jalagi village. And then on the same agreement, the petitioner have applied for appointment, but that was not considered, and the private respondent was appointed. But this honorable court has set aside and quashed the appointment of the private respondent and directed the respondents to advertise the post, allowing both the petitioners and respondents also to participate. So since it's the judgment of in WBC 316 6 of 2017 is of the similar, is erasing of the same agreement. Now, if I can go beyond this. Though it is against me, but since a similar judgment has been pronounced by this honorable court on the same subject matter, similar subject matter, they are the same landowners. Relevant paragraphs will be from para 19. The relevant operative portions will be from para 19 of the judgment.
18.
19. And then basing on the decision of the apex court, this honorable court has set aside and quashed the appointment of the private respondent, and direction was given to address the post. So since the issue in the present case is regarding the same agreement of 1966,
Next.
Next is to the post of Chowkidar at District Veterinary Health Center, Jaluki.
Jaluki.
Yes.
Chowkidar.
Yes.
First one is
The first one is medicine carrier.
medicine carrier.
Yes.
And next one is Chowkidar.
Chowkidar. And the
By
third,
the, by some other person.
my lord.
By whom? Something Lunge. Huh?
Yes.
Some other person.
Some other person.
Same ground.
Same ground. Because the land was donated by different land owners, donors, my lord, not by only one individual. The land was village. So here also, the petitioner is claiming appointment on land ownership against the vacancy. However, it was not considered and the private respondent was appointed. On the strength of the same agreement of
Same agreement.
1966, yes, my lord. All these three petitions are on the strength of the same agreement, 1966 agreement. Only the
Jaluki
post is
village.
different.
Parent district,
Yes,
Jaluki village.
Jaluki village.
Jaliku,
Jaluki,
Jaluki,
yes, Jaluki,
Jaluki village.
yes,
Same agreement, same
yes. And
prayer. Then third one is
the third one is to the post of Chowkidar under the establishment of executive engineer, irrigation and flood control.
executive engineer.
Chowkidar, establishment of executive engineer, irrigation and flood control. This is also against on the strength of the same agreement. The petitioner is claiming for appointment, but the private respondent was appointed against the against the said post.
Here, in next to writ petition, there a private respondent.
Yes,
Are you appearing for private
Mm.
respondent in this matter?
in 1 and 2, she is appearing for the
The
private.
first two item, I'm referring. to
First
the
two
first
item.
one, my lord.
Respondent, what is your ground? No, before that, we'll hear the government. Third, private respondent.
Yes, lord.
Okay. So we'll first hear the common, same affidavit.
No, different affidavit. I filed different.
Then
same
let's see first one.
On the same, yes, Your Lordship.
Hmm.
The first, Your Lordship. The PPC 7th of 2016.
Yes.
Your Lordship, the petitioner has read it out. However, Your Lordship may allow me to read the agreement again.
Affidavit by,
State respondent, Your Lordship.
huh?
State respondent. 1, 2, 3, 4, and 5.
Where's this affidavit? This is where 6. This is the one. Yes.
Lordship. Lordship, allow me to read the agreement.
Yes.
Lordship, the page 16 of the writ petition and type copy at page 18, Your Lordship. Of the writ petition. No. Page 18, my lord.
Yes.
Now, Your Lordship, the first two para of the agreement is relevant. It says, Your Lordship, as already agreed to earlier, we, the undersigned, on behalf of the Jaluki village, hereby offers, Your Lordship, 1, that we have voluntarily given our land as specified below to the Zelian Kuki Tribal Council for establishing the division administrative headquarters by the government. Number 2, that henceforth we shall cease to have any claim on this land, either collectively, individually, or collectively. Your Lordship, we have voluntarily given our land as specified below to the Zelian Kuki Tribal Council for the establishment of divisional administrative headquarters by the government. Meaning thereby, Your Lordship, they have given their land to the Zelian Kuki Tribal Council for establishing the divisional administrative headquarters by the government, and it says they shall cease to have any claim on this land, either individually or collectively.
Correct. No dispute.
No dispute.
Hmm.
So, Your Lordship, after giving away their land, the question of they being a landowner, how does it arise, Your Lordship?
No, it's not a dispute that lands belongs to them. They have voluntarily given it away.
Yes, they have voluntarily given away.
They will cease to have any claim on. They are not claiming.
They are not claiming that they are the landowners.
This is part, it's okay. Serial number 4. You read serial number 4?
Yes, Your Lordship. Then it says that we decline to take any compensation.
Yes, that is also not dispute.
Your Lordship, compensation is paid. This is where the dispute is, Your Lordship. They say that we decline to take any compensation for the land in question, but request the government should give every facility to our village in the town areas, such as opening of our village block, allotting plot in the town, and preferences for government service. That is what it says. Now, Your Lordship, since they have given away their land to the Zelian Kuki Tribal Council for establishing the divisional administrative headquarters, Your Lordship, the government, Your Lordship, has purchased the plot of land from the Zelian Kuki Tribal Council by executing a deed of release, which is at page 7, annexure A of my affidavit in opposition, Your Lordship. Page 7, annexure A.
Yes.
I may be allowed to read, my lord. Deed of release. The deed of release is made on this 13th day of September 1970 by 1 Sri Mangalhar Zelian, Chairman, Zelian Kuki Tribal Council, aged 52, son of such and such of Bengal village, residing in the first village of Kohima district. Your Lordship. And paragraph 2. On my own behalf, hereby witness that I have, on my behalf, have received from the government a sum of rupees 20,000. The compensation for 100 acres of land at Zaluki at the rate of rupees 200 per acre. In consideration of my release and discharge of my right of occupations and possessions of the land, my other rights are interests in the land described in the schedules, attached in the land, and also in full compensation for all standing trees, timbers, and other forest goods therein. Worship country, that I do not declare that I have been adequately and sufficiently compensated for the interest and rights, and that I have or had in the said land, Your Lordship. Therefore, that I on my behalf affirm and declare that and from this day I shall have any right or interest in the aforesaid land. I have hereby do state affirms and declare that and from this day I shall have any right or interest in the aforesaid land. Paragraph 6, that I on behalf solemnly state, declares and affirm that I have this day renounced, relinquished, and surrendered to the government all the schedules attached thereto. Paragraph 7, that I have further declared that the right and interest of my own have been fully and satisfactorily compensated and discharged only, having received the sum of rupees 20,000 only.
Is it the same area which they have donated?
Yes. Yes.
Same area?
No, because this, as per this agreement, it was signed in his own personal capacity, not
And who
on
gave
behalf-
them the authority?
or not on behalf of the village or not on behalf of.
But you have already transferred it to the.
Yes, Zilia, they were the negotiators, they were mediators, because at that point of time,
No,
they were very remote, so they were just mediators. And
they're literally giving away.
this deed of 1970, it clearly speaks that I, Shri so and so, chairman of so, age of so and so, son of so, is residing in the face of so and so. On my own behalf, hereby witness that I, on my behalf, have received. It all speaks about I myself on his behalf, not on behalf of the villagers or on behalf of the community, nothing like that. It's specific. Maybe he has sold his portion of a land, not the entire land of the village.
Where is your affidavit in reply?
Correct.
Have you filed reply?
No. No. But from the language, it's understood.
No, you just don't read what is not there. You have been given a chance to rebut that stand.
Yes, madam. But I thought like since the language is service, I will just justify to the court that this is the language, so I may not require to file reply. Because this language itself is very clear.
Your case is that you have transferred it voluntarily, parted it to the council, tribal council.
Yes.
Is the chairman of the tribal council in 1970s. This agreement is of 1970.
Correct. And then that agreement was in 1966.
Yes, after you have given it to the tribal council, then he has taken the compensation.
We have given since the Jaluki Tribal Council was the mediator, we have all negotiations were done through the mediators.
But then you have given it to them first.
Yes.
Your agreement says so.
On the request of the government. We have
Obviously, at that point of time, 1960s.
66, yes.
66, there must be some kind of mediator and all.
Yes.
So whatever, since you have given it to them, tribal council, whether they sold it, whatever, it's up to them now. He's the chairman.
Yes. But this was not in the capacity of as a chairman representing the village. It was in his own personal capacity. He has sold his own land. From the language itself, it's very unclear. Everything is I on my own.
Continue.
Lordship. Now, your
What
lordship.
is next page?
Sorry, my lord.
Next page.
Lordship. Now, receiving the said amount, your lordship, the petitioner also have given a money receipt. The next page is the money receipt, your lordship. This is given by the again by the chairman of the Zelenguki Tribal Council, your lordship. Now, your lordship, the next page, that is page 9, here, your lordship, it is a letter by the sub-divisional officer, civil, Jaluki, Nagaland, to the office of the sub-divisional, to the director of husbandry and veterinary, Nagaland, your lordship. Now, the petitioner here is claiming over a land where the office of the veterinary and husbandry stands in Parent, Jaluki. Now, this letter says, your lordship, subject disbursement of land compensation. Disbursement of land compensation, lordship. Sir, with reference to your letter in such and such dated 26/6/1970 and letter dated such and such dated 23/7/1970. On the subject cited above, I have the honor to state the payment of rupees 20,000 compensated for 100 acres of land has been paid to Sri Chairman Zelenguki Tribal Council on 18/9/1970. Deed of release in the rare statement along with the actual receipt in duplicate are enclosed herewith as desired by you. So the government has actually purchased the land, your lordship. Where is the local sender of the petitioner to even challenge the action of the government, your lordship? How can the petitioner still says that he is the landowner when he has relinquished his rights then and there by executing this agreement? Wherein he himself has clearly stated that henceforth we shall cease to have any claim on this land either individually or collectively. And now, your lordship, the petitioner are here before this court seeking the government to comply with agreement number 4 of the said agreement. How about agreement number 1 and 2, your lordship?
No. It's because of para 1 and 2, they are asking for appointment to give them preference on government's job.
Yes.
Because they have already donated. They are not
Yes.
claiming it back. Only as per the concept of the serial number 4,
Lordship.
they are asking.
Yes.
They
On the
can,
basis of land ownership.
yes.
Yes.
They
But
can-
how are the landowner, your lordship?
They have given in that condition only. They have voluntarily given the land to the council,
Yes.
which is for establishment of administrative
Yes.
headquarters.
Yes. On the ground.
And
On the ground.
they are not claiming it back. Therefore, they are claiming only for preference under the group 4 or grade 4 employees.
Yes. Yes.
That's all.
On the ground, the no compensation has been taken by them. Also, look at the document here. We have duly compensated the Zelen Kuki Tribal Council. They have given their land, your lordship. They have given the right of their land to the Zelen Kuki Tribal Council.
Thereafter, is there any policy of the government? 2018 policy.
Yes.
Yes.
Policy is there.
Yes.
You are not claiming on the basis of the policy.
No.
Then issue is not there. The judgment which you have relied is on the basis of the policy.
Yes.
I think this court has also passed an order, some orders.
Because this petition was filed prior to that notification of 2018. When that notification of 2018.
So
was not
obviously,
existed.
unless you amend your petition, you cannot claim.
Yes.
And therefore, I don't think so. They have established that on being parted, on being given to the council, they have purchased it from
Correct.
council.
Correct.
Once it is purchased, government cannot. You may ask the council.
Yes, your lordship.
They have
And it says preference.
preference only. Now we are
Yeah.
saying that without giving the preference to landowners, why the respondent number 5 was appointed? That is the whole issue. Why the private was appointed?
No, first you establish your right, then we'll come to respondent number 5.
No, my lord, in terms of the agreement of 66 in para 4, in this case,
In
stated that
terms of agreement
preference.
64, you are not. You have already given away your given away your land to the council.
Yes.
Council has given to the government. Government has paid the compensation, and your preference should have been without compensation. It amounts to giving you a compensation. Because once you transfer it to the council, when the council received it, it's amounts of compensation to you only. And you are not basing on any policy of the government.
No. Because there was,
So
just
matter-
basing on the strength of the
Matter ends
agreement.
there. Sorry, sir. And you have not filed any reply to this government when it was filed?
Long-term back, Your Lordship.
2019.
I filed my affidavit, Your Lordship, on the,
2019.
yes, 22/2/2019.
My lord, the same, they have taken the same ground in the,
You may withdraw and file a fresh petition in terms of the policy at best. Otherwise, there's nothing. It is not disputed that you have given the land to the council for the establishment of headquarters. And under that agreement, you have said you decline to take the compensation
yes,
because you want some plot of land there or the preference in the government job. That was the condition. But then your council, the person whom you have, entrusted the ownership given, they have accepted the compensation. So your the ground of not accepting compensation, it's gone.
my lord, but what about the notification also issued by the additional deputy commissioner saying that preference in this agreement has to be honored,
What agreement?
the agreement of 1966?
That's something as per that in agreement you have given it to the council. Tribal council, they have accepted the. Let us read the agreement.
Page 18, is already agreed to earlier with the understand on behalf of the Jaluki village hereby offer that we have voluntarily given away our land as specified below to the Ziliang Kuki Tribal Council for establishing the divisional administrative headquarters by the government. That
Come to the serial number 4, straight.
4, that we decline to take any compensation for the land in question, but requested the government should give every facility to our village in town area, such as opening of our village block, allotting plot to in the town and preference for government service.
Yes.
At that time,
We decline to take any compensation.
yes,
The council which you have entrusted or given the land, they have taken the compensation. So you ask from them. And you have not disputed this agreement, 1970 agreement, where the compensation has been received by the council. Is it sign is there? Receipt is the chairman of the council. Maybe 1960s and 70s, including your agreement, has not been happily drafted. But then we'll have to go by the contents. You have filed a petition in 2016, affidavit they filed in 2019. You have not done anything. You have not taken any steps disputing this. Maybe it may not be genuine, but unless it is disputed or rebutted, we'll presume it to be, we'll accept it as a genuine. So in that case, this judgment is not covered. So this, whether the appointments of the respondent is bad or good, will not look into it.
Man, why I have placed the judgment was by the same donors.
No, donors, there was a case, this was a case, you will have to go by the fact.
Yes.
It says they have claimed it as per the policy.
It was subsequent.
Subsequent
by the state respondent.
Subsequent
that was
the
taken into
policy.
consideration, yes.
They have based on the policy. But then in that policy,
only one time appointment.
Only one more time appointment. So they are also not entitled. At the same time, the appointment of the private respondent were found to be not as per the law. That's why it was also set aside.
Well, here the petitioners are saying that we have not been compensated.
Same
So yes, my lord, I agree.
order I have passed, this court has passed. Like this one.
My lord, and then since the district administration will be in the best position to give a decision whether land was compensated or not. Verification. may
You are
be
not
taken because that also.
disputing it.
They have not disputed that, Your Lordship.
Either you withdraw or dismiss.
In that case, my lord, I may be allowed to withdraw. So that I may be allowed to withdraw in that case.
I'm not forcing you, huh? Because unless you rebut all this case, I mean the documents, and based on any policy, I don't think. The private respondents were appointed in the year 2015.
2014, my lord.
2015.
How you have been allowed to continue till that?
2014.
Why you have been allowed till
Lordship,
today?
my appointment is
14,
on regular
6,
basis,
7,
Lordship.
8, 9 years, huh?
My appointment is on regular basis, Lordship.
Without following due process.
My appointment is on regular basis.
That's why, without following any selection process.
Lordship, I have applied and the department found me fit and I was appointed, Lordship.
On what basis? What is your, why you have applied just like that?
Lordship,
Was there any selection process? What about the appointment?
Lordship, the selection process, as far as selection process is concerned, maybe not.
Huh?
Maybe not, Your Lordship. Maybe not, just on the approval of the government. Both the petitioners as well as the private respondents, all of them applied. And
So you picked up the private respondent. There's no selection process. Then we'll definitely interfere.
My lord, if the petitioner is not going to withdraw the petition, allow us to submit our submission.
If
the petitioner is not going to withdraw his petition, allow us to make our submission. Allow us to make our submission.
I'll allow you, but what is there? First, you just answer me whether it's a selection process or not.
My lord, I have question on the locus. My lord, who can file this writ petition? The affected landowners who are signatories in the agreement. That can be me, my father, or my grandfather. In the present case, the petitioner is not a landowner. Number one, the land belongs to Chaloki Village Council. That which signifies that the petitioner is not a landowner. Number one. Number two, assuming but not admitting that petitioner can be appointed as one of the Chaloki Village Council member. But in the present case, the land has already been given to Ziliang Tribal Council. We have already given the whole right.
Agreed. All agreed.
And now
I accept it.
Even the Ziliang Tribal Council has compensated the Chaloki Village Councils by paying rupees 1 lakh and a land in Dimapur. I have annexed at page number 18 of my affidavit.
Agreed. I accept your submission.
And thereafter, the petitioner has no locus to challenge my appointment. Next, in the case
that
of
locus we have left behind in 2016, not now.
In the case of the WBC number 1010 WBC number 8 of 2016, WBC number 8 of 2016, which is item number 104. Here, I was not appointed, but I was regularized. So the petitioner and the respondent are not at the same footing. I was working on ad hoc basis, and my case was considered for regularization when the subsequent vacant post arose.
Under what law? What is the rule?
Because
Is there any regularization policy?
To that effect, my lord, to that effect, I was regularized because
Under what rule? Any rule?
because I was the
No,
law.
if it was under the rule, no issue. You tell us the rule. If not, you say no. And
No.
what is the policy? Policy of regulation. If there is no rule, and if your service has not been regularized as per the rules, then what is the policy of the state?
To that effect, no. But it was,
Then
but it was
it's
with
illegal.
the government approval. Necessary approvals were granted by the
Not
government.
necessarily,
for
forget
my
about him, not necessarily him. As you are aware of that. Trillions of people are waiting in the queue to get jobs. That's why all this constitutional scheme of public employment has to be adhered to.
To that effect, yes.
Forget about, that's why I'm saying, let us accept your submission. You are correct, so far as he's concerned. Forget about him. But then he or she has a right to compete with you. If it is advertised, if it is as per the selection process.
To that effect.
Is
yes.
not it?
Yes.
In that case, your case will be interfered. But you don't have the case too. Either you will withdraw or will pass on merit, will dismiss it.
I need your lordship to pass necessary orders.
Huh?
I need your lordship to pass necessary orders.
So you are not withdrawing. Think about it. There is a reason also.
Yes, then my lord, in that case.
No, you think about it. I'll give you some reflection time. See, your basis of claim appears to be, because you have not taken any steps. Now, as per this judgment, these are all the same agreement, relying on the same agreement. They have relied on some government policy notification. It may fit in you, but if your case is disposed of as per your pleadings and the facts of this case, there may be a hurdles for you in future if in case you decide to ask for. That is, I made it very clear. But if you think that you may want to avail another chance, then you may withdraw, will give you a liberty.
In that case, my lord, I may be given some time to, I may be given a liberty because I have to consider. The problem with me was, I was out of the context with my client. So I could not.
He may not be interested.
Yes.
That's a good reason.
I could not file my reply also because I already prepared, but I could not. But anyway, my lord, I may be allowed to withdraw with liberty to file afresh if necessary with the.
No, liberty is not necessary. Once you withdraw it, if you have a fresh cause of action, you're always there. Giving, not giving, it doesn't make any difference. If you can show same facts, same ground, it cannot be, that will be barred. But if you have a subsequent and fresh cause of action, there's no bar. Is not it?
Yes.
So what do you say? Withdraw. With a liberty. Okay, we'll grant liberty. I'm not forcing you, it's up to you. If you are not withdrawing, I'll decide the matter on merit, which I have already indicated. All right. Because you are not able to, do you have anything more to submit?
No, my lord.
That's what I'm saying. That's the reason particularly I'm asking. We have to withdraw or we should pass the order on merit?
Well, then I may be allowed to withdraw.
Withdraw.
If I can get some fresh documents that incorporating that, I would file my fresh petition.
Not just because withdraw, don't just because withdraw that this court has suggested you. Think about it.
But my lord, I was of the impatient that since the similar case was decided, and then all the issues are similar. And then whatever grounds they have taken in this petition, in the affidavit
So-
of position of this respondents.
Nagami,
They can.
in that case, we'll allow him to withdraw the petition with the liberty to file a fresh if so advice. Because tomorrow, with that liberty also, if he has the fresh cause of action and subsequent other relevant, because in this case, because this was filed in 2016. And your policy, there's a policy in 2018. So neither they have amended the petition, they have not they have filed any all these subsequent developments. So tomorrow he may have some grievances. There's still your policies in existence.
Correct. It is still. I don't have any objections.
In that case, they are also safe now.
For now.
It's like they say, no, Geo or Ginedo, live and let live. If you are not getting anything, let them be enjoy for some time.
I was
Is that it?
that impatient for this.
Live and let live. Hard Mr.
And long comment.
N.
Long comment.
Longkumar, Learned Counsel for the petitioner. Same order into three this position, huh? And also had
Takakichu for respondent number.
first we'll record, nah? Record the government booklet. 1, 2, 3. Mr. K. Angami. Huh? N. Angami, sorry. N. Angami, Learned Senior Government Advocate for the state of Nagaland. Item 1. Item
Takakichu in respondent, item number 103 and 104, that is WBC number 7 and 8 of 2016.
Takakichu, Learned Counsel for respondent number 6 in first and second, huh? In writ petition 7, 2016 and 8, huh? Then writ petition 9, Poseko Forte for respondent number 6.
Lordship.
huh?
Lordship.
Are you getting me? Same order, that in third writ petition, respondent 6 will be Poseko Forte, huh? Next para. Mr. N. Longkumar, Learned Counsel for the petitioner, because this will be separate order, huh? Submits that he may be allowed to withdraw this writ petition. Withdraw the writ petition with a liberty to file a fresh Mr. Next para. The prayer of the Learned Counsel with petitioner is allowed. Accordingly, this writ petition is disposable on withdrawal with a liberty to the writ petitioner to file a fresh, if so advised. In all the three cases. That's it. Explore, try to explore
Yes, my lord.
some better,
Yes.
better grounds and all.
May it please your lordship. Lordship, I'm appearing on behalf of my senior counsel for the appellant. Lordship, due to some unavoidable circumstances, my senior had to leave the premises of this honorable court. Kindly list the matter after a day or a convenient time of this honorable court.
What is the matter? It's in 2017 matter. What happened? Noksing Tila,
Yes, lordship.
your senior.
Yes.
What happened to him? What unavoidable?
she had some unavoidable circumstances.
What
Lordship.
circumstances?
She
Tell
was
us.
present today, Lordship, in the morning, but she had to leave the premises of this honorable court.
What is this poker marlin or this poker mar? Angame,
Lordship,
what is this?
Lordship, actually, I'm not in this matter. This matter is handled by additional GV Shokre. However, the petitioner, it seems that the petitioner's counsel has informed her that she will not be able to take up the matter today. So she also has left for some of the other lordship, the official duties, your lordship. Still is about to hear.
When do you want?
Lordship, I pray that this matter may be fixed after a day or convenient time. Of His honorable court.
Next week.
Lordship, the next week somewhere Thursday, because your lordship, the V Shokri will be out of session for some to appear some matters in the principal seat on Monday, your lordship.
Thursday.
Thursday, your lordship. Next Thursday.
On the prayer of the learned counsel by the petitioner. List this matter on
31.
8/20/23.
Obliged, Lordship.
Yes.
May I please, Lordship?
Yes.
Lordship, I'm standing on behalf of my senior Tongpok Pomoner.
Where is Tongpok?
He had some prior engagement, Your Lordship. So
Huh?
he couldn't make, he had some prior engagement. So if this matter can be listed for hearing after a week,
What is the matter? Huh?
then. Lordship.
One is 2000, two is 2016-17, one is 2022. What is the matter?
Lordship, the matter is that the petitioner is claiming to be a landowner.
Same.
No, on the basis of a special permit given to his father just for the purpose of cultivation. Your Lordship, 2016, 58, WPC 58 of 2017 and WPC 207 of 2016. Here, Your Lordship, these two writ petition actually has become redundant for the fact that the government has now cancelled the special permit allotted to his father. Your Lordship.
Which was the subject matter in 107 and 108.
Yes, Your Lordship. Now that is under challenge in this WPC 88 of 2022.
Okay.
So if 88 of 2022 is decided, Your Lordship, then it will cover these two writ petition, WPC 58 and WPC 207.
Special permit for cultivation.
Yes.
So what he is claiming now?
He is claiming to be a landowner, Your Lordship.
Okay.
It was just given for the purpose of
He is
cultivation.
claiming the land.
Yes.
He is claiming the land
He is claiming the land.
from the government.
Yes, from the government. So that with not only claiming the land, he is actually selling of the some plot of land also, Your Lordship. There's the reason why we have cancelled it. And that cancellation order is under challenge in this WPC 88 of 2022.
Now, when the matter is subsidized, how you can cancel it?
No, Your Lordship, in fact, here.
Tomorrow, your senior is ready. We'll see tomorrow.
Your Lordship, tomorrow, there are 2-3 matters already listed. A date has already been fixed, Your Lordship.
Tomorrow,
Your Lordship. It will be difficult for me to take up this matter tomorrow, Your Lordship.
then day after?
If it can be listed next week, Your Lordship, somewhere next week.
No. We'll see. We'll see, and because it's 2016-17 matter.
Yes.
So we'll see if it's not, we'll accommodate you.
Next week, Tuesday, Your Lordship. A fixed date may be given. Tuesday, Your Lordship, next week, Tuesday. I don't want to unnecessarily adjourn the matter again, Your Lordship.
We'll see day after. In view of the matter is 2016 and 17.
The day after, your lordship, it will be a division bench.
Huh?
It will be a division bench, your lordship.
After division bench, we'll see.
Lordship, I have some difficulties actually, your lordship, if it can be listed next week on Tuesday.
Tomorrow,
Sincere apology, your lordship, tomorrow.
what about your senior tomorrow?
He's ready, your lordship.
Huh?
He's ready, your lordship.
Is ready? Tomorrow, what problem you have?
Lordship, three matters are already listed for hearing tomorrow, your lordship.
This court?
Yes, my lord.
Huh?
Not in this court, in court number 1, your lordship. I'm really with sincere apology, your lordship. Tomorrow there's some difficulties, your lordship. If it can be listed next week on Tuesday, your lordship.
Okay then. On the prayer of the learned council of the parties, list this matter on Tuesday is
29, your lordship.
29/8/2020.
Lordship. I'm deeply obliged, my lord.